Okay. Bring the meeting to order. First on the agenda is approval of minutes from August 13th.
I'll make motion.
Okay, it's been moved. Is there
Yeah.
a second?
I second, although I wasn't here, I did watch the video.
It's been moved and seconded to approve the minutes. Is there any discussion? Seeing as none, all those in favor say aye.
Aye.
Opposed? Carries. All right, public comment. Is there any members of the public who would like to speak on something that is not on the agenda tonight? Anybody online? All right. Action items. We're having a public hearing on the legislative text amendment to the Deschutes County Comprehensive Plan and Title 17 and 18 of Deschutes County Development Code. Kyle, go ahead.
Thanks, Chair. For the record, Kyle Collins, Senior Planner. If you give me a second, I need to get, unless I can share my screen. Go. All right, as the chair pointed out, this is the time and place set for a hearing on file numbers 247-26-0000439-PA and 247-26-0000441-TA concerning text amendments to the Deschutes County Comprehensive Plan of 2011 and Title 17 and 18 of the Deschutes County Code. Staff will outline the hearing procedures that will be followed. Firstly, the project website and the full record for all materials submitted as a part of this project can be found at the URL you see on your screen. Don't worry if you don't have a chance to write this down, it'll come up later in the presentation as well. So please note that the Planning Commission will hear oral testimony tonight, receive any written testimony, and consider the testimony submitted at this hearing. The hearing is also being recorded. The Commission may make a decision on this matter today, continue the hearing to a date certain, or leave the written record open for a specified period of time. The hearing will be conducted in the following order. County staff will give a brief report on the issue. City of Sister staff, as the applicant, will provide an overview of the proposal, and then we will take any testimony from agencies or any interested members of the public. Following testimony, the Commission can request staff to answer any additional questions. Please note that this is a hybrid public hearing with both in-person and remote participation. For all of our in-person participants, if you wish to testify, please fill out one of the sign-up sheets and submit it to staff. I think we've covered all of that, but if anyone didn't, you can find those in the corner. After your name is called, please come up to one of the tables at the front of the room before beginning your testimony. And before starting your testimony, please provide both your first and last name as well as your mailing address. For any remote participants, if you want to testify, you must be logged into Zoom or have called in using the Zoom dial-in option. When the chair asks if anyone would like to testify, you will need to use the raise hand feature to notify the Commission. To do this, please press the raise hand button on your computer or smart device, or if you've called in, please dial *9. In addition to any oral testimony, if you have written testimony to submit, please hand it to me directly after you've provided that testimony. And if you are participating remotely, you can submit your written testimony via email to my email address on the screen here. Please note that the chair and staff are responsible for conducting an orderly hearing. Any testimony or behavior which is inappropriate will be addressed and may result in that member of the public being removed from the hearing. Questions to and from the chair may be entertained at any time at the chair's discretion, but cross-examination of people testifying will not be allowed. However, if a person wishes to ask a question of another person during that person's testimony, please direct your question to the chair after being recognized. The chair is free to decide whether or not to ask such questions of the person testifying. Prior to the commencement of the hearing, any party may challenge the qualifications of any commissioner for conflict of interest, and this challenge must be documented with specific reasons supported by facts. Should any commissioner be challenged, the member may disqualify himself or herself, withdraw from the hearing, or make a statement on the record of their capacity to hear and decide the issue. At this time, do any members of the commission need to set forth any information that may be perceived as conflict of interest?
Does any commissioner have anything to disclose? If so, please state the nature and whether you can proceed. Aye.
Does any party wish to challenge any commissioner, the member of the hearings body based on conflicts of interest?
As no challengers are presented, the hearing is now open. Staff will proceed with a brief report.
Thank you, Chair. I'll try to make this relatively quick, given that we have quite a bit of testimony expected out of both of these hearings tonight. We've already had a work session on this issue 2 weeks ago, so a lot of this will be retreading the same ground, but I think it'll be helpful for members of the public to give a general overview. So the proposal under review is a set of legislative text amendments to the Deschutes County Comprehensive Plan and Title 17 and 18 of the Deschutes County Development Code, or our zoning code. The comprehensive plan designations for any property across the entirety of Deschutes County control the specific zoning districts which apply to those properties. So it's really a 2 levels of review. Properties receive a comprehensive plan designation, and then based on that specific comprehensive plan designation, they are assigned a zoning district, and the zoning district itself controls the actual rules and standards that apply on those individual properties. So the proposed amendments that the city has brought forward would update the applicable zones that would be allowed under a Sisters Urban Growth Area plan designation. Again, that's the comprehensive plan designation for properties that are inside the city of Sisters urban growth boundary. So this is just my cartoon version of basically trying to explain the way all this works is you get a comprehensive plan designation that's captured in the larger Deschutes County Comprehensive Plan and codified in a big map that we have for the whole county. That trickles down to zoning districts. You can think of things like the rural residential district as one of our larger rural residential subdivision zones. And then finally, you get development standards that control what you can build there, the sizes of property, setback standards, all of the relevant land use regulations that you might think of. So an example of this is we have the rural residential exception area. Under the rural residential exception area plan designation, you have a lot of different zones that could be applied, but one of the more common are rural residential zones or the RR10 zone. We also have things that are described as combining zones. You can think of them as overlay additional sets of standards that apply to specific properties, usually based on some nearby geographic feature. You can think of things like floodplains or rivers. We have certain scenic view sheds in the county associated with certain waterways or road corridors, and those are all applied onto individual properties. And then based on those overlapping sets of standards, the base zone, in this case RR10, and any combining zones that might apply, like our landscape management combining zone, you get to allowed uses, minimum lot sizes, setbacks, etc. And importantly, under the example I just described, all of those sets of standards are governed by Title 18 of the Deschutes County Code. That's the largest set of our code in general that deals with land use regulations, but we do have others that apply in different areas of the county. So one of the other possible comprehensive plan designations that we have is the Sisters Urban Growth Area. This applies to all lands that are located within the city of Sisters urban growth boundary. And again, based on that plan designation, there are different zones that could possibly apply. One of which is the Urban Area Reserve Zone, or the UAR10 zone. There is a floodplain specific zone that is inside the city of Sisters urban growth boundary. And then finally, we have airport overlay zones that apply to properties that are either airports themselves or within a certain distance of the existing Sisters Eagle Air Airport. Importantly, again, all of these specific zone designations are governed by Title 21 of our code, which is a completely separate section, but still covers various land use regulations. So why does this matter and why has this proposal been brought forward? So statewide planning goal 5 covers natural resources, scenic and historic areas, and open spaces. This is one of the statewide planning goals that we are required as a local jurisdiction to address anytime we make different decisions governing land uses, regardless of what they are. And it requires us specifically to inventory what are described as significant resources and establish protection standards for those resources that are balanced against other relevant priorities. So we are required to go out, make an inventory of specific natural resources. We have a lot of them in Deschutes County. Some of them are waterways, some of them are seasonal or jurisdictional wetlands, some of them are animal migration corridors. We have certain scenic areas, again, associated with places like Highway 126. And based on that inventory, we then come up with a protection program associated with properties that might be affected by those Goal 5 resources. Jurisdictions there's usually a base set of standards that are required for certain Goal 5 resources, things like waterways and wetlands in particular, but jurisdictions can add additional Goal 5 resources that other places might not have. Our landscape management zone is probably one of the more prevalent Goal 5 resources that we have here in Deschutes County, and it's somewhat unique to Deschutes County in a lot of ways. So based on all that, we have a pretty significant set of Goal 5 protection standards here in Deschutes County, and all of those protection standards, or the majority of those protection standards, are implemented primarily through our zoning code. So the rules that apply to Goal 5 resources and how they're protected are all brought about via, in this case, Title 18 of our Deschutes County zoning code. And that's been in place for, depending on the resource, decades. As I mentioned a little bit earlier, we have several sets of zoning designations in the Deschutes County Code. The first and largest of which that we most of the time are talking about here are Title 18 zones, and they contain effectively all of the standards which protect Goal 5 resources across Deschutes County. That's not, there are some minor exceptions to that, but by and large, if we're talking about Goal 5 resources, the protection standards that are associated with those are all located within Title 18. We also have a Title 21 set of zoning standards, though, and those again apply just to the City of Sisters urban growth area. But it contains none of the zoning districts or standards which protect the county's inventory Goal 5 resources. So there are different sets of rules that apply within inside the City of Sisters UGB than those which apply outside the UGB. In a nutshell, that's all it boils down to. So under the current framework, it appears that if we were to apply a Sisters Urban Growth Area Plan designation on any properties which currently are protected by Goal 5 resources in Deschutes County, that would serve as a de facto repeal of those existing Goal 5 resources. And the reason why this matters generally is that we have quite a few properties that surround the City of Sisters. A lot of them are already designated as rural residential exception areas. Again, those are governed by Title 18, and we have Goal 5 resources in place and protection standards in place under Title 18. However, in the UGB, which is governed by Title 21, none of those standards apply, and thus we have no way to enforce a particular protection regime once properties are brought into the City of Sisters UGB. So the city is ultimately mandated to perform its own Goal 5 work, which involves, again, an inventory and a program establishment. But the timeline for when that actual process is put forward is unclear right now. Properties that are brought into the City of Sisters UGB are required to go through that Goal 5 inventory and protection program. But ultimately, any program that is put in place as a replacement by the City of Sisters wouldn't take place until those properties are formally annexed into the city limits itself. So there's kind of a three-step process here where currently any property surrounding the City of Sisters that might at some point in the future be brought into the UGB, some of those have Goal 5 protections. They have to go through a process to change their plan designation before they can be brought into the UGB. And then the final step is actual annexation and application of city zoning. That middle step, that second step, is where potential problems arise. Because there's no mandated timeline for properties that are pulled into a city's UGB to actually be formally annexed and given city zoning designations, it appears that there is a period of time where we will have removed Goal 5 protections, and there's no timeline for when they would be replaced by relevant city protections. There's a gap that appears to crop up anytime a property that might have a Goal 5 resource is brought into the city limits, or excuse me, into the city's urban growth boundary. So this current proposal seeks to ameliorate that particular issue and allow for certain Title 18 zones to remain as viable zoning districts within the Sisters Urban Growth Area Plan designation. And the specific zones that are being proposed are the R10 zone, the rural residential zone, the multiple use agricultural zone, or the MUA10 zone, floodplain zone, and then 3 of our combining zones, the landscape management combining zone, the airport safety combining zone, and the wildlife area combining zone. The reason why these particular zoning designations were chosen is they comprise a majority of the properties surrounding the city limits of the existing UGB for the City of Sisters. And so those are the most likely properties to be brought forward into the UGB at some point in the future. An additional set of amendments has currently been proposed that deals with Title 17 of our code. Title 17 deals with land division standards, partition standards, so how properties can actually be divided up if they are allowed to be divided up. The current land division standards for properties outside of the city limits obviously are Deschutes County standards, and that actually would still continue to apply even when properties were brought into the City of Sisters UGB. So again, prior to that annexation step, when properties are given formal city zoning designations, those properties are still subject to Deschutes County land division standards. However, the proposal tonight, one of the proposals, is that any properties that are brought into the City of Sisters UGB would no longer be subject to the Deschutes County Title 17 standards, but rather Chapter 4.3 of the Sisters Development Code, which is the City of Sisters parallel set of regulations dealing with land divisions and partitions and lot line adjustments. It's intended, the whole reason for the Title 17 amendments, the proposed land division changes, there are certain land divisions that are allowed under Deschutes County Code that could potentially complicate future efforts at future urbanization when properties are brought into the UGB but not yet annexed. And it's possible that could cause confusion and consternation for the City of Sisters as they seek to actually expand, principally things like roadways, other utility infrastructure. You can imagine that parcelized lands in general are much harder to bring inside city limits and effectively and efficiently urbanize. So the purpose is to avoid that particular outcome. The proposal is modeled on some existing code language that we already have that deals with the City of Bend. The City of Bend put this in place many, many years ago, and effectively they have exactly the same language, which says once you're inside the City of Bend's UGB, even if those properties have not yet been annexed, they're only subject to the City of Bend's land division standards at that point. Staff's not aware of any specific application of that particular code standard. That doesn't mean that it has never happened. It's just we are unaware that any property is ever brought into the City of Bend's UGB and then decided to go through a land division at that point prior to annexation. Possible it's happened. It's possible it could still happen at some point in the future. We're just not aware of any exact examples. So I'll talk about other pending proposals, which is the other item that's on the agenda tonight. There are obviously two other pending legislative matters with some relationship to the current process that I'm talking about right now. The first is the City of Sisters UGB amendment, and the second is a set of companion amendments to Title 21, which is the Sisters Urban Growth Area zoning ordinance. The City of Sisters and Deschutes County's joint management agreement says that the City of Sisters is ultimately responsible for applying to make specific amendments to Title 21 of the county code, which is why it's not being brought forward to the Deschutes County Planning Commission. Ultimately, that goes through a city-run process. We will bring that back to the Deschutes County Planning Commission, not through a public hearing process, but simply as a review and acknowledgement before ultimately whatever that recommendation that comes from the city is passed to the Board of County Commissioners for a final decision. Importantly, however, I brought this up for general context, but the current legislative amendment proposal needs to be reviewed under its own merits. So even though there's obvious relationship between these two, ultimately they have to be reviewed as separate proposals. And the reason for that is we have certain applicable standards for all legislative amendments that any member of the public could make, including the City of Sisters in this case. And we weigh those against the existing procedural standards that we have in the Deschutes County Code, the relevant standards of the Deschutes County Comprehensive Plan, and then any relevant state rules that might apply and the statewide planning goals. So those are really the overarching list of what we have to review this particular proposal. So even though there's a lot of interlocked pieces here. We understand that that can be confusing both for yourselves as decision makers and potentially members of the public. These are separate applications and need to be reviewed as such. There's a lot of uncertainties with this particular proposal. This is not intended to be an acknowledgement by staff that this particular proposal is unfit or could not move forward as proposed. It's just there are a lot of questions that we as staff have that we don't have definitive answers to. So I just want to bring light to some of those. There's numerous matters of first impression that at least we as staff are unaware. Some of potential outcomes for these amendments don't have precedent, at least in Deschutes County findings. No case law that we're aware of or state statutory language. It doesn't mean that there are not answers to these questions. It's just we as staff do not have expertise at this point in time to answer them on the fly. Public and agency comments. We've only received one agency comment so far on this particular proposal. It's from our senior transportation planner. Ultimately, he reviewed these proposed comply with the transportation planning rule or goal 12 of the statewide planning goals. So no expected changes to transportation impacts associated with these comp plan and text amendments. Public comments, we've received 2 comments from 2 individual parties to date. Both of those are split broadly between support and opposition. I won't go into much detail, but you can find all the substantive issues associated with those comments in the record. Next steps. As with all of your public hearings, you have a few options to move forward. You can continue the hearing to a date and time certain if you wish. You can close the hearing today, but leave the written record open to a date certain. You can close the hearing and set a date for deliberations. Or finally, you could close the hearing and commence deliberations tonight. And with that, I will take any questions that you might have.
I don't see any.
Tony, is your hand raised?
Nope.
Tony.
Oh, Tony, go ahead.
Yep, sorry about that. I started my audio before my video. So Kyle, you said staff still has some questions. Are there any questions you are specifically researching or seeking legal counsel on at this point?
At this point, I would say we are largely leaning on the applicant to answer many of the questions that were brought up in the staff report that was included in your materials tonight, as well as the staff memo.
Okay, thank you.
Great, thanks.
Of course.
All right, guess ready to open the hearing. First, we have Chris Kobach. And on deck,
I believe the applicant gets.
oh, okay, sorry.
Yeah.
I was getting ahead of myself. Got to move on to the next hearing.
Good evening, everyone. Good. Thank you, Chair Cyrus, Vice Chair Kelly, and the rest of the planning commissioners. Appreciate your service to the community and your attention, continued attention to this application and the UGB amendment itself. My name is Scott Woodford. I'm the Community Development Director for the City of Sisters, and I'm have with me tonight our team members in person for this meeting. To my left is Matt Hasty, the project manager from MIG. Missy Ryan of Bateman Seidel is the city's attorney on this project. We also have Andrew Parrish from MIG, should be on the screen and available for questions. And we also wanted to introduce our city manager, Jordan Wheeler, who's in the audience, if he could just raise his hand. So I want to thank the staff for their time that they've put into this, the crafting of this ordinance, or crafting of this text amendment. We couldn't have done it without them. Once it was identified, there was a lot of coordination between us and the county staff, and we are thankful for the good partnership that the City of Sisters has maintained over the years with Deschutes County to help us craft this proposal, and something that we think is a great solution to an identified issue. During the workshop, I believe one of the commissioners had asked if staff is this a good thing? And this is a good thing. This is going to address a gap in the county's code that potentially could have left some properties that were brought into the Sisters UGB without important environmental protections. So we're here tonight to propose what we think is a pretty a simple and elegant solution to provide that vital protection that we all want, the county wants, certainly in the City of Sisters' best interest to make sure those environmental protections are in place, because those properties are going to be coming into the city someday, and they could be park space, they could be, future neighborhoods. So this is definitely in our best interest, and so we think we'll have a great solution and a great proposal in front of you tonight to correct that issue. So just a little background. This was made aware to us through the UGB amendment review, where county staff identified that there was a potential gap here in the Deschutes County Code. And it's really not a surprise that there's gaps in codes, especially parts of codes that don't get used very often, including this section, Title 21. Last time it was utilized was back in 2005. And at that time, there were no Goal 5 resources associated with that review. So it probably wasn't brought to anybody's attention back then. And so it's no surprise that nobody knew this was lingering out there. And but the good news is that this can be corrected very easily with the solution that we put in front of you. And it doesn't just apply to Sisters; it applies to the Bend urbanized area, Redmond. These are the same issues. It's not just a Sisters issue. It's not a sign that there's an issue with the UGB amendment. It's just merely an oversight, a gap in the county's code. So once we found out and recognized that there was an issue, the city staff, in conjunction with its consultants, prepared text amendments to both the county code and to the comprehensive plan to address it. It was a great fee, great cost to the city, again, to correct this issue with the code. But in the interest of time, we felt that we needed to be the applicant so that we could get this forward to the commission and to the board in a timely manner. Kyle did a good job of giving an overview of what the and how the solution, what the solution is. We'll also go into a little more detail in terms of the mechanics of the proposed code amendment. He mentioned that there's a parallel process going on with the Title 21 portion that is the city's responsibility to process, given the structure of the joint management agreement. And action has been taken on that Title 21 amendment already. The City Planning Commission has recommended approval, and just last night the City Council also reviewed the Title 21 amendments and are recommending that the board approve those amendments. So the city was taking care of their portion of the amendments. So county staff has acknowledged that there's some legal uncertainties in the report and have indicated that these are questions that will be the responsibility of the applicant to address, and we will address that as part of our application tonight. It's as Kyle mentioned, and during our discussions, this is not, the uncertainties are not to be taken as that the staff doesn't think this is plausible or doesn't think this is a effective solution to the problem. I think has been made clear. It's just that these particular solutions that maybe not have precedence or have not been done in this way in Deschutes County. It doesn't mean that they are not legal or that they're not fine solutions. It just means that they haven't done it that way here in the county. It doesn't mean that it hasn't been done in other parts of the state, and we'll provide some details into why that shouldn't matter to this application review. So it's true that these amendments are separate from the UGB amendments, and they should be judged on their own merits and their own criteria. But they are critical to the UGB amendment process and our timeline. So we would respectfully request that the commission review the criteria, and we believe that we've met the criteria and recommend approval to the board. So with that, I'm going to hand it over to Matt Hasty to continue on with the presentation.
Is this guy working? No. Oh. Right. Thanks, Scott. And we have a presentation, which I think your staff is going to pull up, and we'll kind of walk through it briefly. Not too many PowerPoint slides. I always try to make them not super long. And some of it, actually, Scott will have covered already. I'll cover a little bit of it, and then Missy will wrap it up for us. So really, the purpose of this has already been discussed by Kyle and by Scott. We're really, at its heart, trying to make sure we continue to protect these Goal 5 resources during that sort of interim time between when land is added to the UGB and when it's annexed to the city. So that's really what we're doing here. And trying to basically help fix an issue that, as Scott said, is an issue with the county's code, but has implications not just in this area, but has implications in other areas too. These specific code amendments are aimed at the area that's ultimately in the Sisters urban growth area. And it's not just a few properties. This could apply ultimately to any properties, you know, intended to be brought into the UGB at any time. So it's a pretty, actually has a broad impact. I'll just kind of note that. Again, what we're trying to do is make sure that we can continue, the county can continue to apply essentially the proper overlay zones to the resources in this area after it's brought into the UGB. And then I will also just note, actually it went out of my head. Sorry, I'll think about it in a minute. So that's kind of it. I think on this slide, other folks have talked about this. I will also note that we have a better font. We did not use this font. It must not be in somebody's system. It's like, I hate it when the font's like, looks like a typewriter, but anyway, so sorry about that. I won't walk through the proposal here because really Kyle did a great job of this and I don't want to repeat all this. So Kyle's already described the proposal in detail, so I won't walk through that. And at this point, I will turn it over to Missy and she will talk about the questions that staff raised in terms of uncertainties. I will note before she does that, I'll just say a couple of things around that. One is just that your county has a fairly complicated code. I've worked on codes across the state, and it's not a bad code, but it is complex. And I think that's part of the reason this issue wasn't identified sooner. I mean, the Portland metro area codes are similarly complex, and even they don't take exactly the same approach. So, you know, but I will say that in other communities I have worked in, it is not uncommon to allow multiple base zones to apply to a single comprehensive plan designation. So multiple zones can implement a single comp plan designation in communities around the state. So I'll just kind of note those couple of things about what I've seen in other communities in the state. And then also, I think Missy might say this too, but just because something hasn't been done in exactly this way in this place doesn't mean it can't be done. So I will stop there and pass the mic down the table.
Hello, commissioners. Missy Ryan with the law firm of Bateman Seidel. We've been assisting the city as special land use counsel. Our firm is land use counsel to many small and medium-sized cities in the state, as well as Washington County and Benton County on special matters. I've been a land use lawyer for a long time, even though I know I look really young. I've been practicing land use law for about 22 years, and for almost 20 of those years, I was a LUBA referee. LUBA board member, it's called now. It used to be called LUBA referee. So I do have a lot of experience with all of the codes in the state, in all of the cities and all of the counties. And I do agree with Matt. Deschutes kind of takes the prize in complexity, and Washington County is a close second. So I'm really here tonight to address some of the uncertainties that the staff report called out. We did submit what we tried to keep a concise 6-page letter addressing the uncertainties into the record, and I don't know if you've had a chance to review those. Essentially, I can go through each question if you would like to keep the slides up, or I can answer questions. It's really whatever you prefer. If there isn't a preference, maybe I'll just go ahead and hit the high points. Is there any way we could get the slides up again?
Yeah.
Thank you. Oh God, that font is terrible.
Sorry.
Can barely see it. So the first one sort of addresses, can Title 18 zones be used for lands located in the Sisters UGB without additional modification to the City of Sisters and the comp plans given their structure? I took a look at this question in detail. I don't see any state law prohibition on it, and I did see that the county has used the mechanism of retention of existing Title 18 zones to assure resource protection in the past in a couple of different decisions that I found. Those are in my memo on page 4 of the memo. So I'm pretty confident on the answer to that question. The second question, does there need to be an order of operations, I guess, consistency between the comprehensive plan and the zoning designation? The only real guidance we have on that is Baker versus the City of Milwaukee, which guides that the comprehensive plan and the zoning designation must be consistent, but doesn't otherwise specify how the order in which that is to be achieved. There's no state law prohibition on that either. Can we have the next slide? Okay, thank you. Question 3 really relates to Goal 5 protections, which is, can the EC analysis that Deschutes County completed for its Goal 5 resources be relied on for lands now covered by a new comprehensive plan designation? My understanding through many LUBA cases that involve the Goal 5 rule at 660-023-0250 says that in order to apply Goal 5, you can apply Goal 5 in many ways and adopt a program in many different ways. And one of the ways you can adopt a program is to continue existing zoning protections until you have developed a different program. So we don't think that that's an obstacle. Next slide. Thanks. Do you want to say something about that?
Oh,
Seems like you do.
yeah, I think what I was going to say, just to add a little bit to that, is that, all right.
Oh.
Yeah, a couple of things, I guess. One, we went through a recent process with you all to update some of your zoning designations and found that we did not need to go back and redo the EC analyses because we weren't changing the proposed uses. We weren't identifying new conflicting uses. You have a program in place. And so none of that has changed. So we do not believe any changes or new EC analyses are required because those things are the basis of the EC analysis, essentially in the EC program. So that's all I would add.
The next question relates to the subdivision code. The answer to that question is in the Title 17 amendments, which is how the City of Bend has also accomplished this, managing this potential situation, as well as the existing joint management agreement between the county and the City of Sisters. And the final question is, I'll just loosely call it the order of operations. So the way that we propose that these amendments be processed is that the current amendments that are before you be adopted first, and the statute that addresses post-acknowledgement plan amendments at 197-625, 3 and 4 provide the roadmap for this. And if the text amendments are adopted first, and then the UGB amendment is adopted next, that will comply with the statute. This is often done, really routinely done in other jurisdictions. I could not come across a LUBA case that addressed this issue, and I feel like that might be because it doesn't get appealed on that issue because it's obviously allowed under the statute. So we feel, confident that this is allowed. And I'd also just want to note that there have not been any comments from the county. We appreciate that in respect to our answers, and there haven't also been any comments from the public with respect to the answers to these uncertainties. I do want to just note that while we appreciate the county planning staff addressing these uncertainties, I do think it's important to keep the focus on the application at hand, because applications always really, in truth, present matters of first impression, because all applications have to be evaluated on their own facts and their own merits and based on the criteria. And so while the uncertainties are important to address, what's really important is for the Planning Commission to evaluate this application against the criteria and determine whether it's met. And that's all I have to say on that. Does anyone have any questions?
I have one.
Mhm.
So who would have jurisdiction of these properties? The county or the city?
I can answer that question.
Yeah,
I think
thanks.
it'd be helpful for staff. So that pursuant to the JMA itself, which is again, that joint management agreement between the City of Sisters, it is a county code. Title 21 is part of the Deschutes County Code, but all of that code is administered by the City of Sisters, and that would remain unchanged, regardless of how this particular set of amendments would be carried forward.
So if somebody outside the sister city limits wants to do a land use action, they would make application to the city?
In the case, a property specifically, just so I'm clear, it would have to be a property included in the urban growth boundary for the City of Sisters, but not yet within inside the city limits. So we need to make a distinction there. And pursuant to the JMA, the City of Sisters is ultimately applying a set of Deschutes County standards for any development action on those properties. So it's a little bit of a hybrid, but the city is ultimately the one that has control over those particular sets of standards.
Right. So they would pay the fees and they would apply to the city.
Correct.
And would they also get to vote within the city limit for the city council then?
I don't know the answer to that question.
So, okay. Anybody else?
Yeah.
Oh, Mark, go ahead.
Are there any examples for the city of Benco? This is the subdivisions for people who did end up filing an application for a land use thing to the city. I know you said there were like no issues, but were there examples of anything, or at that point was it pretty set and standard, like it's going to be urbanized?
The only question we really asked, we did check in with the city of Bend just to see if they've had any issues with this process, any difficulties or challenges. And the answer to that was no, that it's been working fine. They haven't had any particular challenges or issues. We didn't ask them, hey, can you describe some specific applications and tell us what happened? So I am sure there have been some, but none of them resulted in problems or issues from their perspective. So that was the question we asked one of their planners, their planning manager, and that's what we heard.
I think one of the reasons they don't have a lot of it, haven't had any problems or much experience with it is because most people choose not to do subdivisions within their property, knowing that their property is in the urban growth boundary and that they might want to sell to a developer someday. And if you have small lots right in the middle of your the value of your EGB as well, but it's really a nice protection to have just to prevent it from happening. So yeah, that's what I wanted to add.
Anybody else? Okay. We're ready to move on? All right. First up, we have Carrie Svanstrom. And on deck is Therese Colliner. I'm having a hard time reading some of the writing on these.
Yeah, you can blame my handwriting or my heritage, either one. Carrie Svanstrom, I recently moved to just outside of Sisters. I'm not in the proposed urban growth boundary, but I am in the airport overlay zone. So And apparently I'm one evacuation zone away from the city limits. So fairly close. And I used to be a planning director and now have my own consulting firm. When I was a planning director, we had a Excel spreadsheet we kept called errata or, code oopses. And there were basically things in the code that we found over time that needed to be changed. Kind of common sense things just to make sure everything works together. And I would describe the natural resources amendments in front of you as one of those. It's simply making sure that the existing natural resource protections stay in place and are continuous throughout time. And I'd also say it's not only for natural resources, but as someone who's been a floodplain administrator and worked on hazard plans, it's also a hazard mitigation to make sure that the floodplain regulations and the airport overlay zones are contiguous throughout time. And frankly, as a homeowner who may one day be in an urban growth boundary amendment, I would want to make sure that the protections that my property and my neighbors have and are held to that are currently in place would remain in place until any time a property was annexed. It's simply a no change for the property owners within any urban growth boundary or potential future urban growth boundary. So I am supportive of that. And then lastly, in terms of the subdivision, I definitely appreciate the joint management district system. Instead of just commenting and hoping that the county helps implement your future planning, this is a way for the city to actually have control over what would eventually be in the city and make sure that it respects any specific planning or transportation impacts that may have with that. So I'm supportive of that as well.
Thanks. And then on deck is Ben Welsh.
Hello, Chair Cyrus, Vice Chair Kelly, and other members of the Planning Commission. I'm Therese Kohler from Sisters, and I was the chair of the UGB Steering Committee in 2024-25. Thank you for considering these amendments and, in general, the Sisters UGB amendment. The work and study phase by the community of Sisters has been done. We believe these specific proposed amendments are sound and well-researched by Sisters and Deschutes County staff, and I personally appreciate that both of those staffs work together to hammer this out. We all want to protect Goal 5 resources, and we urge that these amendments be approved ASAP. Thank you.
Great, thank you. And on deck is Chris Kobach.
Ben Walsh, 16074 Parrot Huntington Road. Chair Cyrus, commissioners, thanks for your service to the community, the opportunity to address the issue before you this evening. I'm not a land use attorney or a land use planner, so I can only offer a lay perspective. Apologies. I can only offer a lay perspective on the amendments in front of you tonight, but they seem to be a fairly straightforward matter of bureaucratic administrative housekeeping. And so I urge you to support the amendments. Haven't heard or seen any reason not to. The only one that can come to mind from my admittedly lay perspective would be to obstruct the timely completion of the city's UGB expansion process. So I urge your support. Thanks for your time.
Great, thank you.
Good evening, Chair Cyrus, members of the commission. Chris Kobach. I'm at Buchanan Schmid Kobach, 9th Northwest Newport. This is a better microphone. I'm here on behalf of Mackenzie Meadow Village LLC, MMV, and I've testified before. The first thing I want to point out is I've submitted a letter today in response to the issues. So I just want to make sure that's in the record. Cal, did you get it?
It is.
So I have 2 letters, and I apologize for that, but there's a lot of issues here, and it's like peeling an onion. So I did one letter, and I started thinking about the questions, and I had to do another letter. And the first issue I want to reinforce is I think the process we're doing should be a quasi-judicial process. This is a unique set of facts. It's in the city's application. It's not broad, widespread. I've addressed it in my letter. There's case law explaining what is a quasi-judicial decision, what is not. And the importance is individual notice should have been required for these property owners who are impacted by these proposed amendments. We applaud the city for trying to protect the resources. We just think this is not the right way to do it. And I'm going to get to that now. But before I do that, the city said in their application, contrary to what they said tonight, this is not an issue of countywide impact. Today, they told you it was. In their application, they're saying it's not. So think about that when you consider whether we should have been given, whether owners should have been given individual notice of this application. Now, on the substance in my short time, one thing I want to point out is when the county goes through a plan designation and a zoning process, what they do is they compare the zoning to make sure it's consistent with the designated plan. And here, if you do that, we have the UAR 10 zone where the purpose is to preserve open space for future urban development. And yet they're proposing to change the UAR zone for this property to MUA 10 and RR 10. Well, as I point out in my letter, those allow cluster developments and planned developments which impede future development. And it's important here because contrary to what Mr. Woodford said, a lot of owners of this property are saying we're not coming in. So these cluster developments are going to be very attractive to people that have this property, and it's going to be inconsistent with the whole purpose of Title 21. The city hasn't even addressed that in their application. So you're going to have people, you're going to tell them, and this gets to the subdivision thing, which is a big problem. You're going to say to people, you have MUA 10, you have RR 10 county zoning on your property. But you got to go through, so you have cluster developments, you have planned unit developments, and as I point out in my letter, those are very attractive, marketable products. But you got to go to the city subdivision standards, and you're not going to get to do them. So you're going to have some people that own RR10 property that are on this side of the UGB line. They don't get to do cluster developments because they got to go to the city process. You've got a person, same owner on the other side, same zoning on their property. They get to do cluster development. I think that creates an equal protection problem and many other problems. And the ESEE, there's an example of this. When the county, there's a case on this. There are new uses introduced. Right now, under the current application, all of this property would be subject to the UAR 10 zoning. Now, the county or the city wants to rezone and open up these cluster developments. Those are new uses that will be allowed in this property. The county has already found, and the LUBA has agreed with them in the case I cited, when you introduce new uses to a zone that weren't allowed before, you have to do a new ESEE. You have to. LUBA has said that, and they haven't done it. So I think that's another major problem. I am out of time. I'm actually over time. I would like an opportunity to keep the record open to respond to the city's memo because it wasn't in the portal when I looked last this evening. And so I'd like to keep the record open so that we can respond to that. And these are really important issues. So we'd respectfully request that the commission grant that request.
Great, thank you.
Thank you.
Are there any other comments? Is anybody online? Yeah, go ahead. Come up. It might have got on the wrong pile, but
Probably happened.
anyhow.
Thanks, Matt. Carrie Tosello, P.O. Box 730 in Sisters. My family owns a property on the corner of Camp Polk Road and Barclay. My father purchased that property 40 years ago. At the time, I asked him why he bought that property. He said that when the city decides to expand, which they will, it's going to go that direction. I don't think he realized what happened after his lifetime, but he was right. The city is going to grow that direction. I'd like to dispel some of the rumors going around about maybe some property owners not be willing to develop. I don't know who those people are. I've never heard them identify themselves, but I can tell you that we have met with multiple owners in that area that represent more than 100 acres in the proposed UGB. They're all long-term Sisters residents for decades. They're all expecting to be in the UGB. They're all willing to develop their property as well. We've also been approached by Brooks Resources, which I'm sure you're all familiar with, do really quality projects. one thing about Brooks Resources, a former member of the Sisters Planning Commission, having a master plan walk in the door is really beneficial to the process. So I hope that can move forward with that. I'd also like to say the reason we need to move forward with this now is the Sisters School District. My wife and I put 5 kids through Sisters School District. Sorry,
Just
Jessica.
ask a quick clarifying question.
Sure.
Is your testimony about the 17 and 18 amendments, or is it about the second item on the agenda about the UGB?
I thought the first one is the UGB, about moving forward the UGB.
It's the only reason why I interrupt you. I hate to interrupt you, is that I want to make sure that your comments get counted as part of the public record for the UGB amendment. And right now, we're still having the hearing about the.
Thank you, Jessica.
I don't want.
Oh, thank you for doing that. I am talking about the UGB. I thought that's what you were doing right now.
No, we're doing the text amendments.
Okay.
Only.
Can I hold this?
I'm so sorry to interrupt you.
Repeat myself later.
Right. Thanks. Good catch. Thanks. So is there anybody else that has testimony regarding to the text amendment? Okay. Nobody online? Great. Okay. So guess what's your guys' pleasure?
Chair, I might suggest if you would allow it, perhaps giving the applicant a chance to
rebut
to some of the issues that were raised by
We
the
can do that.
testimony.
Yeah, go ahead. Sorry.
I'll say a couple of things, then I'll pass it down to either Scott or Missy. They'll grab what I missed. I think the first thing I'd say is we're not proposing to rezone any land. We are proposing to retain the same zoning. So to sort of say we're proposing to rezone and introducing new uses is not accurate. Second, when I said this is of countywide significance, what I'm saying is this could be a model for use in other parts of the county. So that's the first thing I mean by that. And two, this could apply because it is focused on the Sisters area, and any part of the area around Sisters that could be added to the UGB in the future, it does potentially affect a pretty large area. It's not just kind of a few pieces of property here. So those are a couple of points I would make, and I'll pass it down. And then if these guys want me to say anything else, they'll tell me.
Thank you. Missy Ryan from Bateman Seidel for the record. I wanted to just briefly address, I think I heard an argument that the counties is incorrectly processing this as a quasi-judicial amendment, and I'm sure you're all intimately familiar with the difference between a quasi-judicial and a legislative amendment, but this is very clearly a legislative amendment that, as Matt just said, is a large county policy that may apply to a set of properties, but will apply to all of the Sisters UGB at any time in the future. This is an argument that I'm really familiar with from all of my time at LUBA. It comes up from time to time, and it usually comes up from a party who's challenging a decision who does not have a lot of other solid arguments. One way that this comes into play is that the concept of prejudice or harm to the person that's making the argument comes into play. And typically at LUBA, when we see an argument that a legislative amendment should have been processed as a quasi-judicial amendment, it's because it would have required some specific notice to property owners, like within 250 or 500 or 700 feet. And typically the person who's making that argument, the specific person has to establish that they were harmed by the failure to process this correctly. So it's not something that typically it gets any traction. The main point is that this, I did a quick review of LUBA's cases and my cases, and Almost none of those arguments were ever successful, and I don't think in this particular circumstance it would be successful. These are comprehensive plan text and legislative text amendments. Finally, I would like to request on behalf of the city that the record not remain open tonight, and that the record be closed, and that the Planning Commission proceed to deliberations either tonight or at its September 10th meeting.
Any questions? So I have one clarifying question. So if this passes, will there be any impact or changes to the code that those people will be having to work under? Or is it an identical code transferred from county to city?
It will be the same uses that they have currently, because we're not proposing a rezone. There would, if Title 17 is approved, there could be some changes to how the subdivisions are processed. There would be changes, but otherwise it would be the same uses, same standards.
I guess for me, it brings up a procedural process question of a measure 49 or 59, as far as notice, et cetera. If in fact there are any changes that could be considered a down zone, or any change to what they would have, including a different price structure for having to make application with the county versus city. Are the fees the same between the county and city for somebody, an applicant that would have to go in?
Chair Cyrus, I think you're talking about ballot measure 56 notice, I believe. And we did evaluate this with the county and concluded that measure 56 notice isn't triggered because of the specific language of measure 56 and how it defines rezone property.
Yeah, you're correct. 56 versus, and the 49 claims that would follow.
Around in 1998, I remember.
I might be able to provide a little bit of clarifying information here, because I think we are starting to mix up a little bit of the UGB amendment process and these text and comp plan amendments. So it'll be helpful to kind of distinguish. The specific amendments that are proposed here today are just changes to certain sections of Title 18, Title 21, and Title 17, which, as Scott pointed out, may have potential effects on land division standards that would be applied to those properties. The same is true of the comp plan amendments. They basically just say that these zoning standards can now be brought into the City of Sisters UGB. The specific question of should we provide notice to properties wherein that would happen would occur at the time that the actual comprehensive plan designation itself would change. So at some hypothetical point where a property were brought into the UGB, that would require a change to their comp plan designation, and thus they would receive notice and understanding that, yes, you're now being affected by potentially a separate set of standards. So the two are separate.
Okay, I appreciate it, because this sets the foundation. The actual trigger point would be the
actual
bringing into the
change in
UGB
plan designations. Correct.
Okay.
Good question.
Yep. Anything else?
I think we're good.
Good. Thank you.
Okay.
Appreciate it.
So we're ready to move on now. Hey, what's your pleasure?
I'll make a motion, then we can discuss it. So we've had requests to leave the record open. We've had requests to close the record so that we can start deliberations tonight or at our next meeting on September 10th. The staff ordinarily needs a good amount of time to get the packet together, which for September 10th would, sorry, this is a really long motion. I'm thinking out loud. Basically, I'd like to propose that we leave the written record open for enough time, which we can ask the staff in a second, enough time that the staff can prepare the packet for us to have ready on September 3rd and commence deliberations on September 10th.
Okay. Is there a second?
I second that.
Okay.
So how long, just to get the motion a little bit more specific, how long would staff need to like, how long can we leave? I know it can only be a few days, leaving the written record
Usually
open.
It's roughly a week.
Well, but they would need to have,
Technically, you can
yeah.
leave the record open for as long as you'd like in this legislative.
Okay, and we could still get the info we need by September 10th.
So your packets are ultimately uploaded on the Thursday preceding that particular meeting. So in this case, it would be the 3rd of September. I would likely need, it's going to depend on the information that comes in during the open record period. It's hard for me to say exactly how long that would take, but probably 2 to 3 days, realistically. And that is a crunch timeline, but it's possible.
So that would maybe to get the motion slightly more specific, we would leave the written record open until Monday, August 31st, which is this coming Monday at the close of the business day, and commence deliberations on September 10th. And I am prepared to say a few words while I'm making the motion.
What's that?
I'm prepared to say a few words of why I'm making the motion. Right. Yep. Okay.
Go ahead.
So just to honor both requests, we can move along expeditiously still on September 10th, but it does give anyone who still has some lingering thoughts on their mind a chance to submit those comments in writing so that we can read them before the meeting on September 10th. And I'm just kind of hoping to honor both of those requests.
Any other comments? Yeah. Commissioner Williams.
And I agree with Commissioner Curis. It also allows, there were some records I saw that came in today, and if everyone hasn't had a chance to read that, we can read that information and still ask a question or follow up on it with it being public information to all of the commissioners. Like I can submit something in writing if I needed to.
Anybody else?
And then I was also going to say, by pushing the deliberations to the 10th, it allows us to continue the public hearing where I do see that we have a decent sized crowd, and I'm sure some of those folks would like to talk as well.
Okay. All those in favor say aye.
Aye.
Opposed? Motion carries.
Okay.
All right.
Okay.
Next item on the agenda.
Yeah. Give me 1 second. Again, for the record, Kyle Collins, Senior Planner. Share my screen again. All right, I think this is probably the item most people are in the audience here for tonight. This is a continued public hearing regarding the Sisters Urban Growth Boundary Expansion Proposal. I'm going to try to keep this very, very brief because this will be the third hearing that we've done on this matter. So just catch up for everybody listening. So the Planning Commission's meeting on June 25th. Ultimately, they voted to reopen the public hearing following an initial closure of the public record back in June. That hearing was reopened on July the 9th. And at the July the 9th meeting, the commissioners ultimately voted to continue the hearing to tonight's meeting. So we're just continuing that proposal. The record has been open this entire time. We've received comments throughout. The project website and the full record for this proposal and all the materials can be located at the website you see on the screen here. And again, just to remind everybody, this is a hybrid hearing. So if you want to submit any in-person testimony, please fill out one of the sheets that you can find at the side of the room. And before starting your testimony, provide your first and last name and your mailing address. And if you're a remote participant, you have to be participating via Zoom. You can either dial in or the standard way from an electronic device. Please use the raise hand feature if you want to provide testimony once we arrive at that portion of the hearing, or dial *9 if you're remote and want to provide testimony. So the proposal, just so everyone is clear, the amendment would modify the existing Sisters Urban Growth Boundary and add approximately just shy of 320 acres to the east of the current urban growth boundary. It's all north of Highway 126 and south of the Sisters Eagle Airport. Here's a map of what that proposed expansion area looks like. Again, you can see the Sisters Airport in the upper left corner. You can see Highway 126 at the very bottom of the picture. So public and agency comments. During the initial open record period, we received 3 comments, which is the whole reason that the record was reopened and the hearing was reopened. We received comments from 3 state agencies. They had the opportunity to provide some testimony at the July the 9th meeting. Those comments were from the Department of Land Conservation and Development, the Oregon Department of Fish and Wildlife, and the Oregon Department of State Lands. Those comments were largely concerned with the inclusion of lands within the proposed UGB area that were adjacent to both Whychoose Creek and Indian Ford Creek. Whychoose Creek and Indian Ford Creek are one of those designated Goal 5 resources that we talked about extensively in the previous item. And they're located and identified, inventoried within the Deschutes County Comprehensive Plan. And there are a number of different zoning designations which apply protections to those Goal 5 resources. Here on the photo on the screen, you can see in the upper corner, that's Indian Ford Creek and the associated wetlands that appear with that waterway. And on the bottom, you can see Whychoose Creek and the associated wetlands adjacent to that waterway. Whychoose Creek in particular has some pretty extensive floodplain areas as well. You can see those on the map here. All of these resources, either the floodplain or the wetlands themselves, do extend into several of the properties that are slated for inclusion as a part of the UGB proposal. So it raised some pretty serious concerns to us as county staff, and we've talked about that at length, but just to go over it again in a little bit more detail. We have existing Goal 5 protections in place at the county level for these properties. But it's unclear what happens to properties that are brought into the UGB but not yet annexed into the city. Again, as we discussed in the previous item, it appears that there would be a gap in protection if properties were brought into the UGB but not yet annexed. We don't have a way to maintain our existing Goal 5 protections, and there's no definitive timeline for when properties are required to annex into the city. And so there may be an indefinite period where Goal 5 protections are lost for these properties. So that leaves the city ultimately with 2 options. The properties have to be annexed immediately, along with the establishment of a replacement Goal 5 program by the city for all those affected properties. The city will ultimately be required to do that once properties are brought into the UGB itself. But the actual standards that they put in place, the protection standards, wouldn't apply until the properties are annexed. The second option that they have is that they have to maintain the existing protections under the Deschutes County framework. But those would only be in place again prior to annexation. So just to reiterate this in as simple way as I possibly can, it appears that the rezoning of the properties from their existing designation, which is primarily Rural Residential 10 or RR10, to the UAR 10 zone, which is one of the current interim holding zones that we have in the City of Sisters urban growth area. They're governed by different titles of the Deschutes County Code, and it looks like it would effectively remove those Goal 5 protections in place if we were to move forward with a rezoning of those properties containing Goal 5 resources. Some public comments. We've obviously received quite a lot of public comments on this proposal. There's been 99 to date, including 63 in the initial open record period, and an additional, I believe, 13 in the reopened public record period. A majority of those comments have been supportive of the proposal, but there have been a significant number of comments that have raised concerns with the proposal. So those supportive comments have largely pointed out the fact that there's been extensive public engagement across the entirety of the UGB proposal, even before it got to a formal application with Deschutes County. This process actually started years in the past. It's been going on for, I believe, 4 years at this point. And a lot of people pointed out that they believe it would support the immediate needs of the city to supply particularly housing, but also employment opportunities and some public facilities, open spaces, park spaces, things of that nature. They also point out that if the current UGB process doesn't conclude by July 1st, there are new state rules that would apply and effectively require the city to reignite this entire process. They would have to redo their land needs analysis and submit a brand new UGB proposal. It's unclear how long that process would take, but given the extensive work that's already gone into this current proposal, you can imagine it would take quite a while. They point out that the selected alternative is already adjacent to the existing UGB and existing infrastructure on the ground there. It's composed of parcels that largely have low-density rural residential uses, and they feel those are more compatible with properties that should be brought into the UGB and ultimately urbanized. There are some concerns that any attempts to include the McKenzie Meadows or the MMV property in the proposed UGB amendment would undermine the expansion due to a variety of unresolved legal issues, access concerns, and natural resource constraints. I won't belabor that point or go into details, but we've talked a little bit about that in a staff memo, and there are plenty of comments that address these particular concerns. They also point out that there would be a loss of natural resources by those that are opposed to this current amendment, loss of open spaces and small town values as the city expands. There's concerns regarding, is there actual viable transportation connections to these properties to the east of the city if the UGB does expand in that direction? There are concerns on there probably will need to be access points to Highway 126, for example, and how do you provide safe and adequate access, principally over White Juice Creek is one of the major concerns that's been brought up there. There's also a lot of concerns brought up that the properties that would be brought into the UGB wouldn't be developed in a timely enough manner to actually supply the housing that the city says this land is intended to be used for primarily, although there are some commercial opportunities available there as well. They also point out that there are a bunch of unknowns regarding legal encumbrances on some of the properties, principally in the Barclay Meadows area that are slated for inclusion, a number of CC&Rs, covenants that exist for these properties that might potentially cause challenges in future urbanization efforts, even if properties were brought into the UGB. Their feelings that community engagement efforts didn't adequately touch all parts of the community or ignored certain community sentiments. And some people have expressly pointed out that they'd like to see the MMV, the McKenzie Meadows Village property, specifically included in the UGB alternative, and they pointed out a variety of reasons for that. And then finally, they pointed out some concerns that the properties aren't adjacent to some existing city infrastructure, primarily things like schools and the commercial core of downtown. They feel that there's too much of a distance and a disconnect between the properties that might be included in the UGB and the existing sort of urban core of the City of Sisters itself. Last set of comments I'll take don't necessarily fall in the supportive or opposed camp. They're just sort of miscellaneous comments that wanted to be put out there. They wanted to see a desire to maintain the existing character of the city regardless of which way the UGB expands. Question on the timing of future development of properties that are ultimately brought into the UGB. And then finally, some generic concerns regarding the loss of natural resources or open spaces or impacts to property values, both on properties that might be included in the UGB and those that are just outside of whatever that future UGB boundary looks like. A lot of concerns around wildfire impacts as the city grows farther into the wildland urban interface or the WUI, particularly as they move into more forested areas. And then finally, just a general need that affordable workforce housing is desperately needed in the City of Sisters. And regardless of what transpires with the UGB, hopefully it can address some of those concerns. I'll speak to what we just talked about in the previous item. There's obviously some additional amendments. City of Sisters has submitted a package of amendments specifically to address those Goal 5 gaps that I talked about a little bit earlier in the presentation. Please again note that those items are not under direct consideration, even though we're talking about the UGB amendments, but they're just provided here for additional context. Those amendments, again, would just update the list of zones as allowable zoning designations for properties that are brought into the City of Sisters UGB. So no specific changes are being applied to any specific property as part of that proposal. It's more like changing the menu of possible options. We already talked about urban holding zones a lot, so I won't go into that anymore. Next steps. As with all of your hearings, again, you can continue the hearing again to a date and time certain in the future. You can close the hearing tonight and leave the written record open to a date and time certain. You can close the hearing and set a date for deliberations, or you could close the hearing and commence deliberations tonight. With that, I'll answer any questions you might have.
Any questions? I don't see any.
So again, unless you have questions for me, it might be
I don't have any
turn it
questions
over
for you.
to the applicant.
Absolutely.
Good evening again. Scott Woodford, Community Development Director for the City of Sisters. I've been told I've been talking too close to the microphone, so I'm going to try to adjust that. Let me know if you can't hear me for some reason. So this is, I believe, the fourth hearing that we've had on this application. So we won't go into a complete reiteration of our previous presentations, but we will touch on some key points that have been brought up in the staff report and some of the other public comments. So we'll make sure that we address those. Through this process, we've, like I said, we've made multiple presentations. We've addressed multiple things. You've heard a lot of testimony, both written and oral, and the Planning Commission has asked lots of good questions of the applicant to help you, I believe, understand what the proposal is and what the relevant criteria are for review. And so we've been up for a while, so I think there aren't any new questions, new information that we haven't already heard several times over. Because prior to this venue, we have been having multiple hearings with the City Planning Commission and the City Council, multiple public meetings, multiple steering committee meetings. So none of the information that we've heard and anything new that we haven't already discussed and analyzed and addressed in some manner. So we've been working closely with since we submitted this application in February 11th. We've responded to lots of inquiries and lots of questions that have been raised by the planning staff, and in all cases I believe we've responded to what the questions are and provided information to support the record for the questions that they brought up. And I want to thank them for that, because ultimately I think it's made it a better application. But we've had it for a while. We mentioned the questions that were identified in the code that we discussed earlier, that we have shifted gears through this process to quickly come up with a solution to help address that. You heard that in the previous hearing. Even though it's a little hard to get your head around, because I think it involves so many different titles and chapters of the code, the solution itself is really pretty, like I said, a pretty simple, elegant solution that really improves the situation, increases the protections, and that's a good thing. So, like I said, we haven't had any information through this process that we haven't already heard. We appreciate our partnership with the state and the submission of their comments, and in their letter, their willingness to work with us. It was clear in that letter that their expectation was that we didn't need to do our Goal 5 analysis before the UGB was adopted, but after. It's clearly stated in the letter and the record that was submitted from Department of State Lands. And we followed up with them just to make sure that was the case. And the reason for their letter was to, just as a courtesy letter, to remind the city that that's something that they will be expecting after the UGB is adopted, because in their experience, many communities forget to do that step around the state. So that was the sole purpose of submitting that letter, is just a general reminder to do that. And also extending a willingness to partner and to assist with that process. So we see those letters as more helpful and not raising new information, and certainly not raising any red flags or concerns with our proposal. And I just want to reiterate that this is how much of a community-driven process this has been. That really started over 6 years ago, and it started with the update to the Sisters Comprehensive Plan, which first identified the need for this expansion. And that was adopted in 2021, and here we are close to 2027. We're just now getting to a UGB amendment adoption. Shows you how long these things take. But there are a lot of important steps to go through to get to this point. including the year-long efficiency measures process that we went through that proposed and adopted a lot of changes to our development code to encourage infill so that the actual ask of our UGB amendment was less than what we're proposing today. So we can get more of those units in the city, the existing city. And then finally, the start of the UGB amendment process in spring of 2024. And council, one of the primary tenets of that process was to make sure that there was a robust and intensive public outreach program because we have a very engaged community. And so it also involved hiring really good land use consultants who have done these types of amendments all over the state and are award-winning for their efforts to help us guide through that process because it's not something that we do every day as a staff, as a planning staff. And so that process has led us to today. It's been a systematic approach in determining what the preferred UGB boundary is. So we are now in the last quarter of 2026 and moving closely into 2027. And it's been well documented that the state's given us plenty of time and grandfathered us in under the existing regulations. But if we don't get local adoption before the end of the year, that deal no longer holds. And we would need to basically start the process over with the new rules that the state has put in place. So we are. That's why we started early. We started in February because we knew that there would be some twists and turns, and we hope to get to the end line before the end of the year. We will follow the process in every step of the way that the state has laid out. We carefully consider all properties around the existing city of Sisters boundary in a very democratic and transparent manner. And the concept before you is the concept that the community has said that it wants. So we respectfully recommend that the commission acknowledge this effort and then find that this proposal complies with all the applicable criteria and recommend approval so we can move on to consideration of final approval by the Board of County Commissioners. Thank you very much.
Thank you, Scott. Missy Ryan, Bateman Seidel for the record. I don't have much to add to that. Again, the city submitted a letter last Friday evening, tried to keep it short to about 6 pages. Mainly what I wanted to emphasize from that letter and then answer any questions is the role of the Planning Commission here is to evaluate the city's application for its UGB expansion as it was submitted. We all see proposals that because we are all of us very smart, think could be better or improved, but really this is about the city's self-determination. And so we're asking the Planning Commission to respect the city as a government-to-government partner and evaluate the city's application as it has been submitted and recommend approval to the Board of Commissioners. I also want to answer any questions that anyone has about the letter that was submitted August 21st in connection with the UGB application. And that's all I have for tonight so far.
So real quick clarification. You indicated that this is a city's self-determination, but these properties are not within the city limits.
That is correct, Chair Cyrus. The city's self-determination is that the city has been tasked with providing enough housing to meet the needs that have been identified through all of its studies. And so the city needs to determine where the properties are going to be that come into the UGB. And it's really going to be the city that has to plan for the infrastructure and pay for the infrastructure and support the residents of the city. And so we're asking for that comity, if you will.
Thank you.
And I am going to finish this up by running through another PowerPoint. I'm going to go through it fairly quickly because I think Scott's talked about some of these things, but this is another one that you guys have on your system. And if the font's ugly again, I'm really sorry. So I'll just apologize right now. We'll see what it looks like. Oh, it looks better so far. We'll see what the next slide looks like. All right. I keep forgetting I'm the one that has to advance these. It is much better. So excellent. So I'll just briefly talk about an updated application because we've made some proposed changes to the original application. I want to respond to some of the things that you all raised at the previous hearing, and then just speak a little bit more about how this proposal is consistent with the approval criteria, particularly the statewide criteria for how to determine or structure a proposed UGB amendment and how to evaluate different alternatives. We previously talked about all these things we've been doing, and Scott talked about this, so I won't talk about that one. This is just kind of a reminder of what we're proposing in terms of where it is, the number of acres, both gross acres and net developable acres. And it does have land in it, and we talked about this previously, that would continue to be conserved as natural resources. And so those aren't part of the net number. Those have already kind of been backed out of that. And it does, and part of those areas are in the Indian Ford Creek and White's Creek corridors. This is just kind of giving you a picture of zoning within the city and then the current zoning of the proposed expansion area. As you've heard tonight, we are currently proposing to retain the existing zoning. So our previous proposal was to rezone this to the UAR. That was what we understood, was typical in the county when you're proposing a UGB. We're proposing changing that to deal with all the issues that we spent the earlier hearing talking about. So it did change that aspect of our proposal, but the other aspects of our proposal are unchanged in terms of the boundary of the proposed expansion area. So a few things, again, that came up last time. I'll try not to repeat things that Scott already talked about, but I will just kind of reiterate the information that was brought to you by DLCD and ODF&W and DSL. That was not, as Scott said, new information to us. We were showing maps of those same areas throughout this process. We evaluated those areas throughout the UGB process. So I just kind of want to make that clear. And they were things we looked at in evaluating different UGB expansion area alternatives. We were showing those resources on our maps and had a lot of discussion with community members about the importance of protecting those resources. So I just want to note that, and Scott talked about that as well. ESEE analysis, that term has gotten kind of thrown around in a number of different ways. There is a Goal 14 ESEE analysis, which we did conduct as part of this process. And there's a subsequent ESEE analysis that gets conducted when you're applying a new set of zones, which is not what we're doing now. I will note that in conversations with Department of Land Conservation and Development staff, they stated clearly that we have done the Goal 14 analysis, and in their opinion, we have done it correctly and accurately. So they stated that to us in a recent meeting with them. People brought up the issue of CC&Rs. I always forget covenants, conditions, and restrictions. Thank you. I always forget that one. So this was also a factor that we looked at in our alternatives analysis as it relates to the efficient urbanization of land. And all CC&Rs are not the same. And so we looked at the different levels of CC&Rs. We also received direct guidance from DLCD. You can't not include something simply because there are CC&Rs, but you can balance that information with the other factors here, and that is what we've done. And then finally, people have talked about property owner interest or whether or not someone is prepared or ready to develop their property within the next several years. This is a 20-year amendment. And so we have to think about this in that 20-year time frame, not the next 5 years. However, I think you may hear from other folks tonight that, and you have heard, you'll hear from him probably again, that there are a number of property owners who are interested in developing in the shorter term. And those number of acres would be enough to meet that shorter term land supply or housing supply. So I'll just note that. And you kind of see this photo. This is from one of the community meetings we had. We had 270 people there. We had kind of a pool going on how many people might show up. No one picked over 250 because Sisters had never had a meeting where 250 people showed up. So I think it just goes to the strength of the meeting we had. And many of those people were property owners within the larger UGB study area. So I just want to note that. And then finally, there was a question about would the city proceed with condemnation or forced annexation of properties brought into the city? Annexations to the City of Sisters are voluntary. They're property owner initiative. The city has no plans to go out and do that. Rarely uses that kind of procedure or what's called eminent domain to compel people to do something with their property. The only exception, I think, could be in terms of locating a transportation facility that's of community-wide significance. City of Sisters and other cities, the first thing they do, and they do this for as long as they can, is negotiate with property owners. And I will say from my experience on these kind of things, 9 times out of 10, that is the successful tactic and approach. And it's pretty rare that any city then has to resort to condemnation. So I'm just going to say that in terms of that is not something that happens very often, and it's not something the city is planning on doing. And then I don't think I need to say too much about this because we've kind of already talked about this. I will note there was a comment about, the timing for when the city addresses Goal 5 retirements is unclear. I would say it's clear that the city applies its protection program once properties are annexed into the city. The other thing that's clear is the city is obligated to conduct a Goal 5 inventory or a local wetlands inventory. Wetlands are a Goal 5 resource, though they are required to do that between the UGB amendment and annexation. So the city is fully prepared to do that. So those parts I think are clear. And I think until that time, the county's protections would continue to apply as we talked about earlier. That's my understanding anyway. Applicable review criteria, I will not read all these. We talked about these last time, but I will briefly kind of talk about the criteria that are kind of at the heart of the statewide planning process, the Goal 14 urbanization factors. They are efficient accommodation of land needs, orderly and economic provision of public facilities and services, the ESEE criterion, environmental, social, energy, and economic consequences, and then compatibility with farm and surrounding farm and forest resources. So I'll hit these really quickly. We did do a detailed Goal 14 analysis of different expansion area alternatives. We submitted all of our findings, all of this analysis to DLCD. They did not raise any substantive issues to date about this. They noted some provisions in OARs that we needed to look at just related to that change in rules that happens around, January of this coming year, just to make sure we were citing the right rules, but those were not substantive changes to the analysis we've done. So this is like a graphic from a huge spreadsheet we use to go through the Goal 14 analysis. This is like a tiny little part of that spreadsheet. So this is just to say we did a very thorough Goal 14 analysis. And some of the things we found in terms of how this proposal addresses those criteria, in terms of efficient accommodation of land needs. This is a single contiguous area, mostly undeveloped. Yes, there are properties with homes in this area, but those properties are on average fairly large or undeveloped. It does contain land in the Sun Ranch Business District and along Highway 126, which provides opportunities for future commercial or industrial development, which is an identified need within the city's planning documents. And it contains land that's suitable for parks and passive open space uses. So we talked about, what's that? And a school. And so that's another comment is, well, this isn't close to schools. There's the assumption and the plan that a school would be constructed in this area to help serve residents in this area in the future. Orderly and economic provision of public facilities and services. All of the properties are west of Indian Ford Creek, so we don't have to cross that creek corridor to get water and sewer facilities to those areas. Existing utilities and streets stub to this area. There would be a need for additional public facilities, and that's something we've taken an initial look at, and the city has a grant to look at that in more detail, which is not something that's typically done at this stage, but afterwards, once the area is brought into a UGB. So that's clearly something the city has to do, will do, is planning to do, and already has some funding from the state to do. ESE consequences, again, we do need to look at this at a high level when we're comparing different expansion area alternatives. And we did look at that, and there are some findings related to the proposal. One, this area is close to downtown and contains land suitable for new parks and open spaces and allows people fairly short access to downtown. It has potential impacts to the Sisters Eagle Airport, but there are restrictions in place that help protect the airport and protect future residents. So that zoning is there. And there are sensitive natural resources and wildlife corridors present. And that can be sort of a good thing and a bad thing. I think in the good way, the city is committed to protecting those resources, and those resources provide amenities for people in the future. And that was really important to the community when we were looking at these alternatives. And those potential impacts will be addressed by design requirements and other planning processes. And that's something the city is really anxious to get underway on, frankly. And then finally, in terms of farm and forest compatibility, most of the land in this area is bounded by essentially rural residential areas on one side and urban areas on the other side. So there's very little area that's directly adjacent to farm and forest other than the area south of Highway 126, and Highway 126 helps provide that barrier between those two types of land. And so again, just a reminder of the applicable review criteria. And is there anything else? Oh, and I will pass it back to Missy. I think that was my last slide. And I'm really glad the font looked better. So.
Thank you. So commissioners, the city does request that the commission close the record at the conclusion of the public hearing and continue the hearing until September 10th for deliberations. We don't believe that it's necessary to keep the record open any longer. We've had robust public involvement and robust public comment, which the city appreciates. The city also appreciates all of the very authentic and heartfelt comments on this matter, but it is necessary for the city to accomplish this, by the end of the year. Thank you.
Are you guys done?
We're done.
Okay. Any questions?
Question.
Yeah, go ahead.
Do you recall the vote when you had this in front of this hearings in front of the city council and the Sisters Planning Commission? Do you recall the vote? I think they both approved it, but I was just curious what the.
Yeah, they haven't approved it. In other words, if that's what your implication is, there was a vote, but it wasn't to approve it wasn't approved. Are you talking about the actual UGB amendment or the preferred concept?
I thought that
Are you talking about the
amendment.
The UGB amendment? Okay. Yeah, the Planning Commission, City Planning Commission has voted on it. They voted unanimously to recommend council approve it. The City Council has not yet heard it. They are scheduled to hear it in October.
Thank you for the clarification.
Any others? So I have a question. I asked the same question at the last hearing, and I was hoping the city would actually provide the answer I asked. And that was for a map that identifies those in favor and those opposed by tax lot of the proposed acreage to become into the city. And I asked that actually twice in the past and still haven't received an answer from the city. So would love to have that answer.
I've heard that there's several property owners that object. In terms of ones that are on record, we only have one letter on record that officially says that they do not support, that I know of. I could go back and look at this, and maybe there's two, but that's what I have to go on, is which property owners have actually submitted their comments into the record, and I can show you where those properties are if you'd like.
I just assumed that given the amount of time you've been working on this, that somewhere in the process, somebody would have actually gone out to the property owners and done an inventory and survey of those interested and not interested in participating, which is what I specifically asked for.
Chair Cyrus, can I ask, maybe Matt and Scott and I can answer your question a little better. Can you talk about the specific approval criterion that you're concerned with that question?
Excuse me?
What is the approval criterion that raises that question for you? That we could help answer, that we could address those concerns?
Well, as I mentioned at the last hearing, to me, it's a little bit of a Tetris question in that if you've got a cookie cutter layout of properties and you've got properties that are interested in participate in developing theirs and properties that are not interested in developing, if by chance you have a buffer zone along all of the infrastructure of those who don't want to participate, then by the nature of the process, most of the question becomes moot on whether or not you have any developable property. And so I was just curious as to whether or not you actually have an avenue forward for development of the land that is coming inside the UGB.
So there are multiple ways that properties could come into the city boundary based on just the contiguity measurement. You can, I don't know if you want to put the map back up, but you can see how much linear property frontage there is with the existing city boundary. That if one property owner wasn't ready to develop, doesn't mean that they might not want to develop in 10 years if it's a different property owner or they've changed their minds. But we can see it as the few property owners as a development of the urban growth, because there's so many different avenues with which to propose an annexation into the city. I'm sorry about the spitting into the microphone. There's multiple ways that the UGB could develop if there was only one property owner. Sometimes if that property owner was say right adjacent to Camp Polk Road, is right right in the heart of it, maybe. But even with that, there are other properties around it that could that are contiguous to the existing boundary that could go forward in the meantime. So I'm not sure if I'm answering your question completely, but it doesn't shut off or foreclose development of the UGB based on one property owner objection.
This is not going to be a direct answer to your question. I'm sorry, we don't have that answer because we don't have a map that shows that, because we did not go out and speak to every single property owner. We gave, like all cities do in these processes, we provided the opportunity for people throughout the process. Throughout the process, we notified every property owner individually to say, we are having this meeting. This information is out on the city's website. We are open to having you come talk to us. We did all those things with every property owner throughout the process. And so, as Scott said, some of them we heard from on the record, some of them we did not. I would say we heard from a fair number of them who said, we are interested. And I think you may hear some testimony from other folks here tonight about that. And you may hear some numbers, acres thrown out. So I would say that. I would say my understanding is there is actually a large block of property owners adjacent to the city limits that is interested, and that represents a large percentage, maybe not a majority, but a large percentage of the developable land within the proposed UGB expansion area. And there's additional property owners that we heard from that are outside that area that said, we are also interested. So we did hear from quite a few. We did not create a map because we don't know about a bunch of them. They didn't come and talk to us. So I would say that. And then the other thing, and just to add to what Scott said, is, as he said, there's lots of different ways that development within the UGB could proceed. And it is not assumed to be a 5-year process or time period. It's expected to happen over 20 years. And that's, look, this is not a perfect system, the state system. It's what we have. I always like to say, this is my favorite phrase, maybe, don't let perfect be the enemy of good, because there is no perfect alternative. There is no perfect solution. But we believe, and the city believes, this is a very good solution. And it does provide opportunities for both near-term development and longer-term development. The last thing I'll say on this is, what somebody tells you today, they may not tell you in 10 years or 5 years or 15 years. And that's why the state says, look, one person can't say, I don't want to be in, so you can't move this thing forward, because they might not be around in a few years, and whoever owns that property might have a different opinion. So I just kind of want to reiterate that, because this comes up in every UGB conversation I have around the state, and that is sort of the way the system works, again, for better or ill. So I will step down from my soapbox, but that's how I think about it anyway. But I appreciate the question.
Thank you.
Yep.
Okay.
Thank you.
All right. So would the gentleman that started earlier like to finish his conversation? And what was your name again? So I don't call you a second time when your name comes up.
Kerry Tosello, P.O. Box 730 and Sisters. I apologize if this is deja vu for some of you. I'll abbreviate a little bit of it. We own 20 acres, family does. We've had it for 40 years in the UGB area. We've had multiple conversations with other owners that account for over 100 acres of that UGB, and they're all longtime Sisters residents. They're all eager to be in part of this process. They want to develop their lands. Any rumors you hear to the contrary are simply false. We've also been approached by Brooks Resources, who I'm sure you all are aware of. They're quality builders and have been for many, many decades. We're excited about talking with them in the future about possibly doing a master plan and presenting that to the city, because the city would obviously love to have something like that quality brought to them. One of the other reasons we need to move this process forward, I believe, and I think the other owners in the UGB area agree with, is the school district. And my wife and I have put 5 kids through the Sisters School District. It's a fabulous school district. As the price of housing goes up, less families can afford to come to Sisters. That's just a reality. If we delay this thing, from what I've heard, we're going to start the process all over again, and we'll be back here in 5 years. And the price of housing of Sisters will probably climb past the price of Ben, because Ben's building houses left and right. That will affect the Sisters School District, and that would be a real tragedy. So I would urge the commission to close this thing, move it forward, and let's build some housing in Sisters, because we need it desperately. Thank you.
Thank you. And we'll have next is Kurt Schneller, and on deck is Carrie Svenstrom. You don't want to go again? Okay. So on deck would be Garrett Masher. Go ahead.
Good evening, Chair Cyrus and Vice Chair Kelly and commissioners. My name is Kirk Schuler, and I am president of Brooks Resources Corporation, previously noted. We are developers of large-scale residential and mixed-use residential communities in Central Oregon. Been doing that for many, many years. While we do not own any land in Sisters, we have been working with owners of approximately 75 acres of land that is included in this expansion proposal. Through that process, we have been able to determine that we can meet the city's planning goals with this land, achieving the mix of housing and other uses in open space. So it's encouraging to us. We hope that this process moves forward so we can continue this work with those owners, bringing forth a master plan to the city. We hope that you recommend this on to the Board of Commissioners for approval. And that's all I need to say.
Thank you. And on deck is Ben Walsh.
Good evening, Chair Cyrus, members of the Planning Commission. For the record, my name is Garrett Mosier, here today on behalf of the Central Oregon Builders Association. Thank you for the opportunity to speak here tonight. First thing I'd like to do is just correct a couple things that were stated on the record earlier. First off, it was not a unanimous vote coming out of Sisters Planning Commission. It was a 3-2 vote, if I do recall correctly, but please encourage you to look that up. Second also is there only one property owner on record opposed to this. I've also previously submitted several other letters for property owners in that area. I'd encourage you to look back at those as well. First off, though, why COBA is weighing in on this decision, it's not about picking sides or property owners. It's about picking a path that leads to attainable and affordable housing in an efficient manner. City of Sisters has long claimed that this application is the fastest way to produce the housing and a path of least resistance. The reality is this is a fast track to endless studies, riparian inventories, EESE analysis, and will make clear why our position has been as such. These lands will simply not produce the housing that Sisters needs. The questions this commission needs to answer here is whether this application will work on paper or functionally. The reality is that the employment lands, housing, all of the things discussed here today, plus the goal balance of all 19 of Oregon's land use goals, are not met by this application. We respectfully ask that you not recommend approval of the application before you. Instead, to quote the editor-in-chief of the Sisters Nugget, tap the brakes on the plan in order to get it right the first time. Thank you very much.
Thank you. And on deck is Bill Willits.
Chair Cyrus.
Yes, go ahead.
Can I just make a request of staff, by the end of tonight's presentation, like this is for the county staff. We've had two different, pieces of information regarding something that's definitely public record, what the vote was for the Sisters Planning Commission. I would just like to have, if one of you guys get a chance to research that and maybe get back to us, I think that would be helpful by the end of the meeting.
What I'm looking at right now.
Thank you. Okay.
Thank you.
Ben Walsh, 16074 Parrot Huntington Road, Sisters. My family's owned our home at the south end of Barkley Meadow since 1975. And I think that makes us the longest running current property owners in Parrot Huntington, which is an area of the map that's under some considerable scrutiny. So I would like to say I've watched the land there for more than half a century now. I want to just offer a couple of comments about matters that are in the record of this body already. One, with respect to staff and the excellent work they've done, I think there's an inaccuracy in their comments earlier this evening. There's a map with a light green area over Barkley Meadow that was identified as wetland, and I think that's an inaccurate reference. I think the accurate reference to that colored area is that it's constrained area, and that can mean a lot of different things. And one thing that I will tell you is that in Jessica Salgado of Division of State Lands, in the offsite wetland determination that she submitted into the record as part of that state package, one of the bugs on that map is an actual wetland determination in Barkley Meadow. And my understanding from the property owner who commissioned that is that actual wetland delineation resulted in an approximately 75% reduction of constrained area on their property. So that meadows changed a lot over the years, and the outline of the constrained area, I think maybe MIG can tell us accurately what the sources of that outline of constrained area is. Might be Army Corps of Engineers, might be floodplain, not really sure what all contributes to it, but it's not a clear, simple concept, and it's subject to change with actual delineation. The other comment I want to make is that there's been a lot of comment into the record about homeowner sentiment in Parrot Huntington or in Barkley Meadows or Barkley Meadows First Edition. And I don't really want to speak for other property owners, but on behalf of myself and my family, we support the result of what we view as a really exemplary civic process that's put the AA map in front of you. And I can tell you with certainty that there are some factual inaccuracies, some incomplete or misleading information in representation in the record of this body with respect to homeowner, property owner sentiment in the AA map. I urge you to support the amendment. Thank you.
Great, thank you. And on deck is Kurt Kohlberg.
Jim Willits, managing partner of Mackenzie Meadow Village. Thank you. I provided you a book of facts, and I encourage you to leave the record open and study these facts. and then simply ask the city to rebut these facts. And we'll come to what I think is an honest conclusion. I want to start out by saying this is not an indictment on Scott Woodford, who was one of my favorite human beings. It's an indictment on a broken land use system, and we are part of that. On the cover of your map, you see 10 parcels that have rejected the UGB. We're planting our flag on that. City can rebut it. 2 of them are in the light green, which is the Barkley Airport sub area. 8 of them are in what makes up the Barkley First Edition. 80% of the votes in the Barkley First Edition are no. To bring that land in, you need 75% yes. The math will never work. Not in 5 years, not in 10 years, not in 20 years. That's a fact. Let me see, where am I? We have never been in opposition to Brooks Resources or any of the Barkley Airport. We do want to clarify where there are 2 pieces of land that won't come in. It will have almost no impact on it. Brooks Resources is a great developer, great landowners there, great for the community. That's the green. Where we take a different position is in that blackened area, because the problem is not an environmental problem, although that's part of it. The problem is that the votes will never allow that land to come in to answer that question. And somewhere in here, we have to seek the truth. And so for the City of Sisters to try to perpetuate Barkley Meadows First Edition in and reject MMV, that I believe is the best affordable model in the history of Deschutes County, is painful to sit in the audience and just hear this. So we're asking that you keep the record open. We're asking that you look at points 1 through 3, because we dispute what the city has said in the past, and we give you specific documentation, our traffic study, a letter from the Forest Service, and the 8 votes that are saying no. And then we request that the County Planning Commission requests that the City of Sisters respectfully answer questions 4 through 10. They're questions we've been asking, but we've been pushed away. We've never had the opportunity to get those answers. And so in closing, I'd like to say that until the record is corrected, until questions 4 through 10 are answered, we request that the record stay open. Thank you.
Yeah, go ahead.
Sir,
Sure.
when you say, I just want to be, just to
Okay, thanks. I'm with you. It's confusing.
say that, this map that you provided us,
Yep.
these properties, is this, they say no, therefore CCNRs?
Yes, and you'll hear more from Catherine Levitt. She's gone to Atlantic, because actually there's another property that said no. But yeah, these are properties that we asked the city to go out and poll these people. They never did. So we did. We put a private poll out, and we've got in your binder, you've got written documentation of their no vote. And then you've got, if you go to tab, let's see, if you go through tab, let me make sure, yeah, tab 3, you'll see the various votes, and you'll see their parcel, because it was requested we provide you tax lot.
And I think what I'm wondering, these were part of the public record, so I studied them before this packet. And what kind of caught my attention was this property owner here said that he would be in support. However, his property is not in the new UGB. So I'm a little just trying to clarify,
I'm glad.
these people,
I'm so glad.
they're not coming in.
So here's the confusing part. Barkley Meadows First Edition is made up of 19 properties. The only property that can come in is the dark colored area, this section
That's
on your
what I
map.
think too, yeah.
Yet to come in, each property owner has a vote to change their CCNRs. So what that property owner is saying is, gee, if I was down there where I could come in, I would vote favorably. But because the floodplain completely encroaches on my property and I will never come in for posterity, I'm going to vote no because I don't want the disruption. I don't want my ranchette, the whole concept changed. And I think you'll get more
No,
testimony.
and that helps me. So
Is that,
thank you for
yeah.
clarifying. That helps me.
Thanks. Thanks for that question.
Okay. On deck is Kathy Russell. Oh, excuse me. Tony, did you have a question?
I did. Since I'm not in attendance tonight, is it possible to get a copy of that book that was presented to you folks?
Yes.
That with the colorful map and all that, I do not have that in front of me.
Yeah, we'll find another copy. Thanks.
Great, thank you.
Yeah, my name's Kurt Goldberg. Nice to see you guys again. I'm been in Sisters 45 years. I'm the old guy. This is the young person right here. I'm the old wise guy. This is the young person. I have a question for these three right here. Scott, how far is it from the elementary school? Question, how far?
Actually, Kurt,
No? You don't
Kurt,
know?
you can testify, but we can't get into.
Okay. No. How far do you think it is from Mackenzie Meadow to the elementary school? 4 blocks. Do you think we're gonna have bicycles from the middle to the elementary school? Not gonna happen, is it? They're trying to put houses 3 miles from where planners like yourselves built all our schools, all our soccer fields, football fields. People that sat in your seats before were planners. That's where we have where the schools are. But these people that think they're planners want to put housing now, they're not planners. They need to go back to the valley. People that live in our community say, there's 5 cities that want development where our city wants to do it. The rest of our community goes, what are they thinking? Our kids have to go down a truck route, cross a highway to get to their schools. We're going to kill kids. We're going to kill young families. What do they have to do to get to our churches? They got to cross highways. It's ridiculous. They got housing, bare land that's ready to be built on right now, and it's not even considered to be in the expansion of our urban growth expansion. It's ridiculous. They shouldn't even have jobs, but we have them as our city planners. It's a joke. Our chairman asked twice, how many pieces of property don't want to be considered? Our planner, Scott, said, oh, I think it's a couple. In my world, a couple is 2. I went and my wife went and personally counted the people, how many people did not want to be considered in this expansion. It was 10. 10 is not 2. He lied to you guys. That's a lie. He lied twice to you, Matt.
Can you wrap it up fairly quick? So
Okay, I'll wrap it up, but that's a flat lie. I don't think, if you guys will accept lying, you know, that's not the way I do business.
No.
Thank you.
Thank you. And on deck is Jake Moorhead.
Remote or getting some bad audio on it. Testimony. See if it sounds any better over there. Thanks.
I'm Kathy Russell, 1006 West Collier Glacier Drive. I'm Kathy Russell. Is that better?
You kind of have to talk like right into it.
Okay. I'm Kathy Russell, and I live at 1006 West Collier Glacier Drive in Sisters. Chair and Commissioners, I am here tonight to support the City of Sisters UGB application and ask you to recommend approval to the County Commissioners. The city conducted an extensive analysis of the land available for expansion. That process included an advisory committee composed of citizens, landowners within the potential expansion areas, and representatives of both the Sisters Planning Commission and City Council. The city also went directly to the community through open houses, presentations to civic and business organizations, and council members staffing a table at the city at Sisters Farmers Market. This was not a rushed decision. It was a lengthy, public, and deliberate process. The application before you reflects the decision reached by the City of Sisters after completing that process. This stage of the process is about land, identifying the land best suited to meet Sisters' future needs. It's not a competition between draft master plans. It is not a choice between developers, and it should not be decided by promises about what a landowner may build in the future. Those decisions come later through annexation, zoning, and development review. The city did the work it was asked to do. It evaluated the available land, involved the public, weighed the alternatives, and made a decision. The county certainly has a responsibility to review that decision under the applicable land use criteria, but review should not become an opportunity continually reopening the city's planning process simply because some people prefer a different property or a different development proposal. At some time, process matters, and at some point, a decision has to be made. Sisters has completed its work. Our community has participated. Our elected officials have acted. It is time for the county to act as well. Please evaluate the application that is actually before you based on the applicable criteria and recommend approval to the county commissioners. Thank you.
Great, thank you. And on deck is Catherine Levitt.
Good evening. My name is Jake Moorhead. I live at 69015 Barclay Court. My wife Dominique and I own two 10-acre parcels on Barclay Court. One of those parcels is not included in the urban growth boundary. It's our primary residence, but it does border our second parcel that is included in the urban growth boundary, and that is 69021, tax lot number 1307, a 10-acre parcel as mentioned. Dominique and I would like to express our support for the proposed Sisters UBG plan. Once approved, we fully intend to participate in the master planning process and to work collaboratively with the city and our neighboring property owners. In anticipation of this, we have actively been communicating and working together with many of our neighbors whose properties are included within the proposed UBG. Based on those conversations, we understand that there's significant support of the plan and of all of those that we are familiar with and have been working with. They intend to participate in the master planning process effective immediately. We believe that this presents a very important opportunity for thoughtful, coordinated planning and responsible growth in Sisters. We look forward to being a part of that process. We thank you for your consideration and hope you approve this.
Great, thank you. On deck is Teresa Kohlerer. Hopefully I got it right that time.
Hi, I'm Catherine Levitt, and I live on Parrott Huntington Road, and we are in consideration for being annexed into the city. I don't have a planned speech. I've just been writing notes. This is a tough one for me. It's very, very personal, and I think that the city has a tendency to talk in generalities, and they're saying we have a lot of positive input and so forth. Okay. I live on Parrott Huntington, which only has 8 families living on that road. 5 have said no. 1 living in London right now and so forth, but 5 out of that. Okay, how many more people are not aware of really what's going on? I live in the county. I don't live in the city, and I want to stay living in the county. If I wanted to live in the city, I'd move there. I don't. And so when you say you want some confirmation of, gee, doing a survey, they're saying, well, you know, things change. Well, right now we're talking about right now. We don't have to talk 20 years for these homeowners, I don't feel. I think what we do is we go, and why is it so hard to just send a letter? I don't pay attention, I'm sorry, to a lot of the things going on in the city right now. When my husband and I retired, I had enough of the city because the city does what they want to do. Simple little thing, like I remember when downtown was being redone and they were going to allow people to come in and choose a paver for this, you know, for the sidewalks. So they let the people vote. They voted on a specific paver. Oh no, the city decided it was too busy, so they did what they wanted to do. And that's the way it goes with the city. They want this to pass. They look at statistics. Well, guess what? I'm one of those statistics, and this is really, and it's hard for me here, it's really, really personal. Because I think I've shared with this before, the last meeting. In the last 3.5 years, I have lost my brother, my husband, my mother, my sister, my cousin, and a sister-in-law. And this piece of property is my sanctuary. I don't have to see anybody if I don't want to. I shut my gates, I let it go. But now they're wanting to take that away from me. Oh, no, 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 this is in the future. You don't have to be a part of the city. I say that's bold because as far as I'm concerned, as long as the city has one footprint on my road, then that'll all change. And right now I've got across the creek from me where they're wanting to do light industrial. The developers are already showing up at the doors and knocking on them saying, we want to buy your property. And nothing has even been decided as yet. But there's a map, and it's in your binder, I think, that Mr. Willits put out for you, is a picture. And on the cross over on 126 where they want to do this, and this drives me crazy with all of this construction on the creek. They're wanting to do light industrial on 126. Well, guess what? Now they're talking about, oh, they have to put a bridge across. So that's going to go right through my property. So I want it in writing that they're not going to use eminent domain to take away my property because I don't want that to happen. My husband is now gone. This is all I have left. And it's my place to do whatever I want with. And if someone comes in and does eminent domain and take it away, that's going to kill me. I'm sorry if I'm emotional, excuse me on that. But every time I turn around, this is what the city, this is what's best for the city. Well, you don't look at the people. You cannot even give an answer of doing a survey. You can do all of this research that you've been doing, but you're not giving us any definite answers on who is for it. And I'm just one block. And out of 8 people, 5 are saying no. How about the rest? How about the rest of people in the county who may not pay attention like I have been for the last few years? I haven't been paying attention. Send a letter. What's so hard about that? And get some thoughts. And you don't have to have a letter for the future. I'm talking about right now. So anyhow, I just feel like they're taking away our little town of Sisters, which was a beautiful city. It's now becoming any town USA. They don't look at the people, they look at the statistics, and that's what they want to do. And I don't want to be forced out of my home. So anyhow, thank you.
Great, thank you. On deck, Abby C.
Hi, Teresa Kohler again, 1190 Jansen Court and Sisters. First of all, I really have a very specific request of the commissioners. I, as a citizen here, found it very difficult to listen to Kurt be uncivil to people in the room. And I request that you stop somebody, interrupt someone who is behaving in that manner. Thank you. I'm going to talk a little bit, just briefly, about the Luba decision, because the Luba decision, which very recently, came out that they are remanding the rezone to back to the county for the MMV property. No matter what is ultimately decided on that rezone, that would be a big delay to even consider the MMV property for the Sisters UGB. This process has been delayed already quite a bit by the consideration of MMV. However, there is I'll call it an urban legend or maybe a rural legend that some people hold that the owners of MMV put out there, that only MMV can solve Sisters' problems of needing immediate affordable housing. And this is patently not true. Other builders, other homeowners, other property owners can research and develop and figure out a way to provide affordable housing and more housing, and the city can provide parks and possibly a school over there. So we did, however, go through the entire process with the steering committee, frequently hearing from Bill Willits and his supporters about MMV. We gave them wide latitude to present to us. Jen Kovitz of Hayden Homes, early in the process, came to one of our steering committee meetings and asked very specifically, please, UGB steering committee, send a letter to your city council and ask that this process of rezoning application with the county be expedited. Because Hayden Homes and Jen Kovitz made a very nice request, we considered it and we acted on that. We said, okay, we'll ask the city council to ask the county to expedite. And in the meantime, and I'm kind of conflating several decisions made by more than the steering committee, the planning commission, the city council, and the steering committee carefully considered MMV property all the way along. When the decision came from the steering committee and then the Sisters Planning Commission and then the City Council of Sisters to recommend this concept AA for our city staff to put into a formal application to then come to the county, we first, at the steering committee level, had a very specific vote. Are we going to consider, when we were getting down to picking out which lands it would be, very specifically, do we want to consider MMV lands anymore? And the vote was no. And then we went on to consider the lands that you see before us.
Are you getting close?
I will just say that it's become a David and Goliath situation, and MMV and its proponents are spending a lot of money on lawyers, and it is patently unfair to the process of Sisters up to this point. However, because of the world we live in, they may get somewhere spending all this money and talking to people who may be convinced to side with them. And I'm not disrespectful of Catherine Levitt or people at the other end of the spectrum who think there should be no UGB because there's so much vacant land within city limits right now. But I just want you to step back and see that really the biggest delay that's been to this UGB process has been caused by consideration of MMV and now what you see unfolding before you, that they're pushing any way from Sunday to get it delayed.
I need to wrap it up. Thanks.
Thank you.
Okay, on deck, Monica Thomasy.
Thank you, Commissioners. My name is Abhi Chaudhary. I live at 69033 Barclay Court, Sisters, Oregon. I was the vice chair of the UGB steering committee for the city of Sisters. I own 17.6 acres in the proposed UGB area, and I'm supportive of its approval. And I'm committed to the development, including building affordable housing in that area. I'm working with Brooks and literally all of my neighbors to do this in an expedited way. Right now, the thing that's holding it up is basically Mackenzie Meadows, as Therese pointed out before. I've submitted already a pretty detailed rebuttal of the various false claims made by the Mackenzie Meadows Village team. As Vice Chair Kelly pointed out, for example, when they do the survey, and there's like 10 properties that are saying they don't want to be in, 8 of those properties are not actually in the UGB. So we don't really need them to vote to be in the UGB. Like, it doesn't really even matter what they vote. The CCNRs, I also live in Barclay Meadows. They allow subdivision of the properties, and each subdivision, each partition gets a vote. So if you have 10 acres, if you split them into quarter-acre lots even, that's 4 times 10, 40. That's enough votes easily to amend the CCNRs. There's claims about like elementary school kids can't ride bikes to school, to the current elementary school. My daughter starts first grade this fall and rides her bike from my house to the elementary school. There's actually a bike train of elementary school kids who bike from that area all the way to elementary school all together every morning. So if I sit here debating all the points, we'll be here all night. But I just want to say we have a really good proposal out here. I think the city's done a really good job. Holding it up further is only endangering affordable housing for a much longer period of time. MMV keeps talking about they really want to have affordable housing now, they're shovel ready, et cetera, but if we miss this December deadline, we're punting out building affordable housing for multiple years, because that's how long the UGB process takes. I really, really, really strongly request you to take a vote on it and move forward with the proposed UGB amendment. Thank you.
Great. Thank you. On deck, Kristen Radlberger.
Hi, Commissioners. Monica Thomasy. I'm in downtown Sisters. Let me know if the volume's too loud or too soft. So I have planned comments, but I just have to say, what are we doing here? We have lack of civility. We have accusations of lying instead of asking for clarification of questions and answers. We have private individuals doing polling that you're supposed to use, and then a private individual providing you material, but not for the general public. We have Matt Cyrus asking for a map of yeses and nos. If we're going to do polling, let me know, because I would love to do some polling. But guess what? That's not how this works. There is a democratic system. And what's happening is MMB didn't get their way, so they're getting more desperate and more uncivil. And I think it's time to end this. Given the widespread concerns with I just want to say that I want to put that on the record, because if this goes to LUBA, I think this hearing here will be a key part of that process, and it's going to be in favor of the City of Sisters.
So given the widespread concerns with fire-wise land use planning, as well as concerns about sustaining transparent and democratic processes, I ask you to support the decision by the City Council to choose concept AA. I followed this years-long process, and as everyone has said, most people have said, it's thorough, explicit, deliberative, inclusive. My background is in forest ecology and management, and I think that the Millie Fire, Flat Fire, and Ocala Fire reminds us that Sisters sits in the middle of a fire-prone landscape due to decades of drought. Structures are built with wood, and they're in and adjacent to rural areas undergoing aridification. If the toll gate development were to be proposed today, I expect it would be rejected. And I contend most of the recent phase of the Mackenzie Meadows home should not have been allowed because it degraded the hydrologic services of the Trout Creek watershed, which, by the way, speaking of mistruths or untruths, they originally said there was no water on that MMV property, and I can show you pictures of a stream flowing through it. Traffic congestion already exists in this area, even without wildfire evacuation going on, so further development would increase the likelihood of wildfire, and the watershed would be degraded, and it would put people at risk. We do not want to see people being trapped like they have been in other cities in the country. So basically, here's what I originally wanted to say. The citizens of Sisters funded the analysis and consultation process that was necessary to go through to get to concept AA. The decision makers at all levels assumed that the rezone would stand and that Central Oregon Land Watch would not win their appeal, and they still rejected the parcel. In other words, you could have made a decision earlier. So now RUBA's agreed that Central Oregon Land Watch agreed with them that the rezone was improper. Given a December deadline to get the application to the state, there's not enough time for the county to go through all the required zone change hoops for the city to consider including Mackenzie Meadows. If you force the city to do a new plan, then you'll be costing me and others and sisters hundreds of thousands of tax dollars to pay for new analysis and consultation. And I believe that MMV property would be rejected again. As a taxpayer, I resent being dragged through this waste of time and money. Thank you.
Oh, thank you. All right. Chris Kobach.
Good evening, Chair, Vice Chair, and Planning Commissioners. Thank you for the opportunity to provide public comment. My name is Kristen Reidelberger, and I'm here to share Central Oregon Land Watch's support for a recommendation of the City of Sisters Urban Growth Boundary application. This application is the result of years of extensive work by professional planners, consultants, and technical experts, property owners, elected and appointed officials, and hundreds of community members. There has been extensive research, public engagement, and review. Landwatch supports this application because it is a thoughtful, legally sound plan for growth that reflects the needs and vision of the Sisters community. Oregon requires every UGB expansion to balance the need for efficient urbanization and adequate land for future growth with protection of natural resources, habitat, farm and forest land, and the environment. This application strikes that balance, providing sufficient developable land while protecting the resources that make Sisters unique. Property owner interest in annexation is not a criteria for approval. The state recognizes that a 20-year land need is a projection, not a guarantee or a requirement that every parcel will be developed. OAR 660-024-00401 states these determinations are estimates and, quote, should not be held to an unreasonably high level of precision, unquote. One of Sisters' most important needs is affordable housing. The city has been doing the work of developing affordable housing programs, removing barriers, streamlining processes, pursuing funding, and working with both market rate and affordable housing developers. Sisters is ready to take that work into the next phase of coordinated area planning, and that work requires approval of this UGB. We respect the Planning Commission's responsibility to provide an informed recommendation to the board. However, continuing to send this application back into additional analysis without a clear new issue to resolve risks turning thoughtful planning into analysis paralysis. Sisters needs to move forward so this community vision can start to become reality on the ground. Finally, LUBA's final opinion last week on the Mackenzie Meadows rezone appeal remanded the county's decision on multiple procedural and substantive grounds, rendering that zone change ineffective and unacknowledged. Landwatch urges the Planning Commission to recognize the tremendous community effort and quality of work behind this application, the short and long-term public interests it serves, and recommend approval. Thank you.
Thank you.
Thank you, Chair. Again, Chris Kovac, you have my information. I would agree. Well, first of all, I'm here on behalf of the LLC MMV, but my client does endorse Mr. Willett's comments. And particularly, we're glad he clarified that my client has never argued that all of this property is not going to develop. In fact, I think at the last hearing here before you, Mr. Willits explained the same thing he did today, that he fully supports the Brooks Resource Plan. My client's concern is with the rest of the property, and we agree this is a prediction. I agree with that comment 100%. Our position is the prediction should be based upon some qualitative assessment of the rest of the land and whether it will produce, as the city's attorney said, will it help them accomplish their task of providing housing, needed housing? That's the question. Where is the qualitative assessment? The ESEE under Goal 14, the city did do one, but they did one when the application was seeking the interim zoning of UAR. Our point is they should at least revise that ESEE now that they're introducing new uses. The fix to the Goal 5 is to allow MUA and RR10 uses in this property. That's cluster developments, that's planned developments. On page 4 of the staff memo at your planning session, your work session, the staff told you that if you allow these Title 17 subdivisions to go in, that could complicate future efforts at efficient urbanization. That's exactly what Goal 14 goes for. So all we're saying is if you're going to fix Goal 5 by allowing these new uses, cluster and planned developments that could be very attractive to some of these properties that are not right now committed to coming in, well, do that analysis. Tell us how are those properties going to efficiently develop if you're allowing these competing uses that you admit complicate your efforts at future urbanization. And the second thing is that the comment is really just more about the timing. There's this rush. The city doesn't want to do the qualitative assessment because they have this deadline, January 1. And they say it's because they have to start over. Well, according to my reading of the Oregon Housing Needs Analysis that goes into effect January 1, most of it only applies to cities of 10,000 or more. So I would ask the commission to ask the city to specifically answer the question. If most of that act doesn't apply to you because you're not 10,000 people, what specific actions do you have to redo? What additional costs will you have to? Because this is your chance to get it right. It's 20 years. It's your one chance to get this right. Is it the end of the world to take some more time and do it right if the consequences under this new plan are not that big? We don't even know what they are. We just keep hearing that this rhetoric that we have to start over. Well, it's in writing. I read it. I don't think most of it applies to them. We've actually asked, my client has asked the State Housing Authority to actually advise the city and the county planning commission of exactly what the ramifications would be. This new housing accountability department, we've got a request into them that they've acknowledged to ask to tell you all and to tell the city, here's what this means for you. We should at least wait to see what that state agency tells us before we rush to judgment on a plan that has some issues. There's some good to it, but there's some bad to it. And so that's what we would ask, is that we just not rush this. Let's let the city get it right. Let's let them answer this question. What are the ramifications if we wait and do it right? Thank you.
Thank you. Hey, would the city have some comments for the applicant?
I want to look if anybody is online that might want to
sorry.
testify.
We have somebody online? Nope. Anybody else in the audience? Okay, you guys are up.
Okay, I'm going to talk about a few things. I'll try to be concise. First, property owner consent is not a criterion for bringing land into a UGB. There's no vote by property owners that prevents that land being added to a UGB. So maybe I'm misunderstanding what some of the testimony was about, but sort of saying, oh, these people, we've got these 8 votes and this area won't come in. That's not how it works, I guess. They could choose not to annex. Again, it's property owner initiated annexation, but sort of in terms of whether or not land comes into the UGB, that's just simply not how it works. So I would note that. In terms of the recent comment about, well, we should ask the state what this means in terms of starting over. We have asked the state that. It was the state that told us that. It was the Department of Land Conservation and Development staff. They were very clear, because the city has voluntarily conducted a housing needs analysis and has adopted that housing needs analysis. If we do not do this or get through a local process by January 1st, and we want to come back and pursue a UGB expansion, we will have to redo that housing needs analysis. We will have to redo our land needs analysis. We will have to go back out to the community and have this conversation all over again. So we heard that very, very directly from the state. It's not an issue of the size of the city. It's that all cities have to plan to accommodate 20 years of growth. And the city has been undertaking that process. And so that is why we would have to go back and do it again. I'm going to pass it along because there's a couple other things I want to remember what I have to say, but I'm going to let Missy go. You're probably tired of it.
Hi, Chair, members of the Planning Commission, Missy Ryan, Bateman Seidel for the record. I did want to follow up on Matt. I did have a conversation with DLCD and their council a few weeks ago, and DLCD confirmed that with DLCD grants supporting this process that began in 2021, DLCD has, in conjunction with the city for planning, has spent approximately $380,000 starting in 2021 to get to this point, which is really a significant amount of money that the city just simply doesn't have to replace. Mr. Kobach is just not reading the rule correctly, is all I have to say about that. I want to delicately talk about the Luba decision that several parties have brought up with significant respect to the applicant and their attorney that's in the room. You know, I've been on Luba. It never feels good to have a remand, and it actually never feels good to remand a decision when you're the decision maker, but that's where we are. The remand means that the MMV property is zoned forest. It is a goal for forest land, and it is the lowest priority for inclusion in the UGB. The remand pointed out some significant obstacles to having this approved even on remand, should the decision not be appealed by either Central Oregon Land Watch or by the applicant. Also wanted to point out that of the Luba decisions that are appealed to the Court of Appeals, approximately 80% of those affirm Luba. So it's really only about a 20% chance that Luba's decision would be reversed. One thing that the Luba decision did point out is that the city has some participatory rights, that the Luba concurring opinion pointed out that the city has some participatory rights under this attempt to leapfrog the UGB priority scheme. And I can confirm that the city will be exercising participatory rights on remand and clarifying to the county where exactly and how far along the city is in its UGB process. Do you have anything? And I think that's all I have, unless anyone has any questions.
Briefly.
Yes.
I just wanted to correct for the record, the question was asked about the vote on the planning commission meeting. I think I erroneously said that it was a unanimous vote. I went back and looked at it, and it was a 3-2 vote for approval. I was thinking of the recommendation that the planning commission made a year ago for which boundary that they wanted to go forward with, which was unanimous. So I apologize for that. Also, just if there were more than one property owner on record, I apologize for that. There could have been 2 on record, 3. I think it highlights still the point that we've been trying to make for 4 hearings, I think now, is that property owner, well, it's an interesting discussion item, is not relevant to our conversation and frankly is not anywhere in the criteria and cannot be a criteria in your decision. The UGB amendment state law system is really based on the suitability of the land is the most critical factor that you should be considering. And that was part of the criteria that Matt went through earlier in his presentation. We've heard these comments over and over. This isn't the first time we've heard those. But I would respectfully just note that that is not a criteria that you should be using for review, respectfully.
I did remember a couple more things. I always see you've given enough time. So one quick thing, the ESEE analysis is not based on a specific zone. The Goal 14 ESEE analysis is not based on the assumption of a specific zone. That is the other ESE analysis that the city would do in the future. So there is nothing for us to redo in terms of assuming that the existing RR zone would stay in place. We would not do the ESE analysis any differently in terms of how that is done for a Goal 14 analysis. So that's just not something, that's not the way that works. And then the last thing I would say is, to sort of suggest the city needs to go back and get this right, I think the city would take issue with that. I think the city believes, and we're here to say that we believe we have gotten it right. And we've presented voluminous information in the record and evidence that we have gone through this process properly and correctly. And I would say frankly, overwhelming overall support of community members and sisters affirms that. So I think we've gotten it right. And I'll say it again, it's not a perfect solution, but it's a very, very good solution that is supported by the city. Oh, and one more thing, Missy asked me to repeat our request that you close the record and move to deliberate, if not tonight, then at your September 10th meeting. So thank you very much for the opportunity to respond.
Great, thank you. Any questions?
Oh. No.
Great, thank you. Well, what's your pleasure? Oh, Commissioner Williams.
I do respect the applicants in wanting to close the public hearing. I would merely request, and this is my motion, I move to keep the written record open until Tuesday, September 1st, and set deliberations for September 13th. And I will explain if anyone wants to second.
Can I question it?
13th, the right date?
I might be totally wrong on that. I think it's the 10th.
The question I have is we just voted earlier to leave the written record for our other public hearing open through the end of business on the 31st, which is Monday.
Yes.
And I just wanted to confirm that you're proposing that we leave this one open through the end of the day on Tuesday, September 1st, and maybe ask Kyle if that's enough time.
I would say likely no, frankly. I mean, ultimately the commissioners can do whatever they like and we can scramble and put something together. There's also the possibility that you hold multiple rounds of deliberation. So it's not necessarily set in stone that if you do decide to deliberate on the 9th, that doesn't necessarily mean the decision is reached that night. Deliberations can get pushed further in the future, and so it's not an absolute emergency. But there is probably some procedural sense in trying to match.
Yeah. And if I may, the only reason I said that is I am working in Lapine and Crescent tomorrow, and there's no way I can get that packet tomorrow that was provided. And I would like to look through that information. It was provided by the public, and I could process it and then get questions if I had questions and get answers back. We can do a friendly amend to 5 p.m. on the 31st, and I'll just try to put my big readers on and read like crazy on Monday and get big answers back. That was the main reason I said September 1st was I cannot get that packet tomorrow.
Okay, is there a second?
So
So the motion as I'm hearing it would be to leave the or close the hearing, leave the written record open until close of business on Monday, the 31st. And
I had stated
do,
the
deliberations,
1st.
at our next meeting.
I think she's trying to say something.
So
Yeah,
is that correct?
I had stated the 1st merely because I won't be able to pick the packet up until Monday.
Well, let's see if we have a second on that then. Just see if anyone seconds it.
Right, but excuse me, I thought you had said that you could make Monday work.
I said I will bend over backwards. It would
Okay.
just,
So
if
I
I
would-
have
just-
questions,
I could pick up the packet tonight and deliver it to Tony this weekend.
well, that
I
would,
also have a
that-
copy of this packet that I'll scan to the record.
or if it could be emailed to me.
Yeah, just to point out, so I as staff have a copy of this. I also have all the other physical submittals that we received here tonight, and tomorrow I'll scan these and
It'll be in the record so you can pull it up online.
at the very latest you'll have it by Monday.
Okay, and then my main thing is if I had questions that I wanted to get put out on the public record, that was mainly the main thing. But I would do friendly on close of business Monday and set deliberation for the 10th, along with the Title 17 and 18.
Just to clarify, our close of business is actually 4 p.m., not 5 p.m.
Okay, 4 p.m. You bankers hours.
Okay, do we have a second on that?
I second that.
All right, we have a motion and a second. Would you like to discuss it?
Mainly, I know additional information was presented tonight, and for my edification, I would just like to be able to review it. And if have any questions or thoughts myself, be able to put them out there.
Okay, great. Anybody else? Okay, all those in favor say aye.
Aye.
Opposed? Motion carries. All right. So staff comments. Do you have it?
I've talked plenty tonight, I think, unless you have questions for me.
All right, well,
Al, do you want to give the people in the audience kind of the usual end of hearing spiel for where to deliver materials and how to get them?
Yeah, absolutely. Probably best place to give materials. If you want to give physical materials, you can drop them off at the Community Development Department. That's right across the street. It's 117 Northwest Lafayette. Just make sure that my name and the file numbers, or at least some mention of the UGB amendment or the comp plan and text amendments, are on those submittals. Also, probably the simplest way is to just send me an email with a digital copy. My email address is Kyle, that's KYLE, .collins@deschutes.org. So kyle.collins@deschutes.org. That's it.
hey, Will.
Yeah, thank you, commissioners, chairs. Thanks for leading a long series of hearings. I know this is a longer evening than we normally engage in. Oh, sorry, is that quiet? So for the
That mic.
Other mic.
wow, oh, the tall one's terrible on the.
Well, it's
Oh.
Will.
The other tall one.
Thank you. So just to be clear, the sisters matters are now closed, and this is sort of regular business. So members of the public, right? Are we still in the?
No,
No, we closed the hearing
Okay.
and we left the written record open.
Okay.
And we're now in staff comments.
That was my understanding as well. So just for the benefit of the public, this is kind of a recital of general staff comments. I appreciate your attendance this evening. But just letting you know that there'll be no further discussion at this point of the sisters matters.
Thank you everyone for coming out
Yes.
tonight. It means a lot that you are here.
And you don't have to leave. You're welcome to hang around for a bit, but
It's always interesting. The staff comments are always interesting.
so thank you for coming.
Good evening, again, Chair, Commissioners, your planning manager, Will Groves. Maybe I'll wait a moment for the room to clear out here. Close enough. Yeah, thank you. Yep, a vigorous hearing this evening and a longer time than we spent together for a while. So appreciate all of your time here, of course, this evening. Coming up on the Planning Commission calendar, I'm going to focus on that this evening. We've got Sisters, of course, the UGB and TA deliberations coming up on September 10th. September 24th is it's tentatively scheduled for a Terrebonne engagement report number 2. We've conducted that Terrebonne engagement, of course, and Tanya is producing a report on that. In addition, tentatively targeted for a work session on farm stores. We've been talking about farm stores throughout the year. Initial discussions tentatively scheduled then. Heading into October 8th, a public hearing on the farm stores and Title 22 amendment work sessions. Those are a variety of intended changes to ensure that our procedures ordinance is up to state law and is functioning correctly. Coming up on October 12th, tentatively scheduled is the duplex text amendment review. Currently, that's one of those applications that we've scheduled for a review by the Planning Commission, but not a hearing. As I mentioned previously, there were some concerns for a gentleman in Terrebonne who had gotten kind of sideways of the rule changes in his bank with regard to our rules for attached duplexes, and the commissioners had recommended some changes mirroring but not required by a House bill that allowed duplexes to be detached to try to allow a variety of housing. So we'll be coming to talk to you about that. And also public hearing for the Title 22 amendments, the procedural ordinance, and deliberations for farm stores. Just also noting that the second hearings in both this November and December will be canceled for holidays this year. So crashing into both Thanksgiving and Christmas Eve. So just as you're planning your calendars out, those second hearings again, or planning commission meetings that we would typically have at those points fall on holidays that year. Not anticipating anything emergency that we would ask you to reschedule to a separate date. So just planning ahead there. Noting that there continue to be a large number of plan amendment zone changes passing through the hearings officer and onto the board. Really a pretty heavy load for planning, regular planning, current planning staff, keeping us all really, really busy. I think I talked to you a little bit about our community wildfire protection supervisor, Lauren Street, is backfilling her position. Had some very good interviews for that, have some exciting candidates. Looking forward to calling references next week for potentially filling that position and hopefully getting that team back to 3 people and all the good work that they do. Also, just wanted to let you know that recognizing, of course, that speaking slightly about the Sisters matters is that, this is a deliberation of a sort that you haven't been in a while. Most of the ones you've been doing don't have extensive legal criteria associated with them. Certainly recognize that you're going to be doing some heavier lifting than usual, and I'll be working with my team to try and make sure that you have a digestible deliberations packet that directs your attention to those matters that are before you and gives you some, typically we try to give you some questions that we recommend that you engage with. For those of you who've been on the Planning Commission for a while, you'll remember that those questions are meant as an opportunity for engagement and don't strictly limit you on what questions you might ask or what you might want to debate about, but at least to give you a format of some of the things that you likely are going to want to cover. And we'll be working on that in coordination with legal counsel. And so my intention is that, as we come into those deliberations, that you won't be coming in blind to that, and you'll have a packet that will help with that. And my anticipation is also that we'll kind of start out that September 10th hearing, giving you a presentation on this, kind of the record, the situation of the record, what's being asked of you, what deliberations usually entail. And at the same time, it's important that we're not getting ahead of you. So we're going to provide you some structure, and you can take advantage, accept it, amend it as you go through your deliberations to decide to recommend or not recommend this to the board. And as Colin mentioned, there's nothing that mandates that you close out those deliberations on the first day. If of potential deliberations if you feel not ready to do that or need additional information or analysis to proceed.
Will you guys be able to work together on that packet and like discussing how to structure it ahead of time? I mean, I'm just saying that was helpful when I was like found those pre-meetings to be, because it was a good collaboration between them not getting ahead of us so that you're, leading the structure, but also getting really helpful input on something this
To
complicated.
keep us out of trouble legally.
Yeah, exactly. Like, and also to keep us staying focused on what we can and can't make
What decisions we could make.
right. And so it doesn't go just off on a, rabbit hole or whatever. But at the same time, I think it's really important that the planning commission is its own thing. So
It might be helpful just as general context. So this is hopefully not going to sway any type of deliberative decision, but UGB amendments are somewhat unique in that they have some aspects of what we would normally consider like a quasi judicial review, where there's specific criteria applying to specific things, and we're having to follow a set of rules. And at the same time, they're actually a legislative proceeding. So there's policy choices being made that affords decision makers pretty broad latitude, but you are hemmed in. There are specific state standards that apply to UGB expansions. And ultimately what you're going to be evaluating is, did the city meet those particular standards in its application and its burden of proof?
that would be so helpful to have that laid out of like, these are the standards. Did they meet them? Yes or no? To just help us organize our feelings versus our, like, what are we supposed to be doing here as a planning commission?
Absolutely. And I will certainly do my best to make it
Yeah.
digestible as I can.
Appreciate it.
Anything else from you, Val?
So quick question. So when was the last Bend UGB? I feel like it was, 7 or 8 years ago.
2016.
Oh, wow. Okay, so
Been
10 years ago.
It was before my time.
Shh. Nothing's before your time.
Oh, is that everything, Will?
Nothing else. Thank you.
Okay, Kyle. Stephanie, tell us how much trouble we're in.
Good evening, Planning Commission, Senior Assistant Legal Counsel Stephanie Marshall. Good to be here and to kind of hear the proceedings that were before you tonight on those 2 agenda items. The updates that I have, one pertains to the pending petition for enforcement that was filed by Central Oregon Land Watch and Thousand Friends of Oregon. That was scheduled for a contested case hearing earlier in the month. Several things came up, which resulted in a stay of the proceedings. We are now in somewhat of a no man's land. There was a writ of mandamus that a petition for writ of mandamus that was granted by the Marion County Court, and then a motion to dismiss that was filed. Argument was held. The motion was granted. The order on that motion was just entered today. So things have not restarted with respect to the contested case hearing. And another FYI is that yours truly will be going on a vacation starting on September 9th.
No.
And not returning until September 27th, which is a Sunday. So I will be available after on and after the 28th of September. So
Good.
yeah, I know, right?
I know.
So in that regard, I will of course be monitoring my emails. I will be meeting with legal counsel David Doyle, and also in the legal department, we have just promoted Kim Riley to deputy legal counsel. Not we, but they have promoted Kim Riley, so congratulations to Kim. So she will also be updated by me before I leave on vacation. And hopefully everything will be in good hands within the two of them. And I will be having a long and detailed meeting with the two of them to ensure that things are passed off and managed while I am on vacation.
You deserve it.
Well, thank you.
Yeah,
Thank you.
We're happy for you.
Yes.
Great. Thank you.
You're welcome.
Commissioner.
Yeah, I'll just brief comment. I was thinking about some of the requests we had for respectful discourse, and I think that having been in the chair position, it's really hard because it's so important for people to have their 3 minutes to express their views, and it's just, like you're sort of straddling a line of letting somebody talk and get to what they're saying versus like redirecting people away from very disrespectful ways of expressing those sentiments. And I'm going to say, put me down as a +1 for redirecting people when they are venturing into character attacks as opposed to facts or views or opinions. Once it gets into character attacks and telling people they shouldn't have jobs and things like that, that feels like where the line is from my perspective. But I say that in a sort of gentle way because I would totally understand if other people had different lines of what's considered civil and whatnot. But I think that's where the line is for me. And so I was uncomfortable with that, as well as some of the members of the public who also expressed feeling uncomfortable. But generally, like, I feel you, man. Like, it's just hard to.
Well, and to address that, I mean, I would agree with you that I wasn't comfortable with some of the comments that were being made, but there's also a line between freedom of speech and the ability to express themselves without censorship, even protects speech you're uncomfortable with. And so I was, like I say, kind of it did kind of encourage him to come back to the focus, but yeah, it's kind of, where is the line?
Yeah, I totally empathize with that. Yeah.
So, do you have anything more?
No, I mean, I don't know that anyone else is still listening, but I really appreciated the public tonight. I just felt like the level of testimony was so detailed and specific and passionate and important. So I just really appreciated the meeting.
Great. Commissioner Williams.
Let me see if I am. So from what Will was saying, we're going to get a little bit of a package, and I appreciate that. Having read some of the last few letters submitted on the UGB, a lot of pointing, a lot of suggesting what we should do, and I know that we need to follow the dots, connect them. So I am going to appreciate looking at that on the 10th. And then Stephanie, I don't have as big a vacation as you. I leave on the 23rd and get back on the 28th. So it would be my hope that we deliberate and complete on the 10th.
Well, congratulations, and I hope you enjoy your vacation, Commissioner Williams.
Thank you.
All right.
Clemson
Commissioner
game.
Stockham.
Did Tony have something else there? I'll ask my question for Stephanie now then. There's been the date of this is going back to the UGB for January 1. Does so a decision, whatever that'll be, for county commission, does that need to be made by then, or does it need to be final by then, like the readings and stuff? I'm just curious for the timeline because, of course, or do we even know? I was just curious if they're.
Yeah.
Okay.
Don't exactly know, and a lot of things are in the mix in the next few months to be decided, and before the new board is the new board of commissioner, the new commissioners take their seats, and that date will be January 4, 2027.
I was just curious. I know we'll treat it urgently with deliberating, so I hope the 10th will be when we make it the decision. So besides that, thanks for all the comment tonight, everyone.
Commissioner Kelly.
I love these public hearings just because, especially tonight when we had so much passionate engagement. I think that's what makes this body so cool and unique. And so I also was really kind of excited when Matt from MIG came in the room. I was like, because we've seen him on Zoom so many times.
That's right.
Through so many of these different, and I was like, oh my gosh, I think that's the guy. And it was.
He looked familiar. And
Yeah, I was like,
"Oh,
wait.
you're the guy."
So it felt like kind of a celebrity sighting that he was.
That's exactly right. I was like,
no,
no,
but
that guy.
yeah, I was like, he's familiar. Thank you, staff, for always helping and making this as streamlined or as clear as possible for it. Thank you.
And I have one more question before Chair Cyrus.
Okay, go ahead.
Will, you were going over your calendar. Are we doing a square table work session with the board this year? Because we normally do it in the fall, and I can't remember if you covered that or not.
Yeah, it was covered about a January possible meeting when we have new commissioners.
Okay,
And Will can
okay.
explain.
I thought I heard something and I just didn't hear it in the fall calendar. So, okay, thank you.
Yeah, great question. Chair Cyrus, you got it exactly correctly, is that we thought there might be limited value to getting in alignment with the board in the remaining month or two that they might have at that point. So looking to get you with the new seated board so you can have those discussions for the work plan going forward.
Oh, great. And I'd just like to thank everybody for helping keep me in line tonight. Let's try to rush things a little bit maybe, but no, thanks for everybody. It was a good hearing. We got through almost 20 comments. So it went well and on two different hearings, but the side comment, I would mention that I was appointed to the DLCD Unincorporated Communities RAC. And so if anybody has any thoughts, comments that I could take to that, feel free to reach out. It should be interesting, especially where we've got Terrebonne and Tumalo coming up with some that will be impacted by whatever that RAC comes up with potentially. So.
And just to note, we haven't accepted formally yet, but we've been Tanya and my team have been invited to present.
Oh, great!
One process. So we're gonna see each other in a.
No, that'd be great because like I say, it was interesting the fact that we have, especially with Terrebonne coming up specifically, and Tumalo was also. I mean, there's discussion about things like expansion of unincorporated communities and housing impacts and a lot of the stuff that certainly could be relevant in our county coming up. So anyhow, with that, thank everybody and meeting's adjourned.
Wait.